Out of the list.
Page-wise adjournment.
No, out of the list. Any memos?
Yes, madam.
Hmm.
My lord, this is last posted on 28/5/24. Called this matter of 2 weeks. The urgency is, my lord, the appellant is protracting the issue. It is filed against the arbitration suit, which is went in my favor. And he want to
Here is MFA.
2020 MFA AA matter, my lord. Day after tomorrow.
See, yes.
My lord.
MFA, we have filed one impleading application that has to be posted before this court.
Lord,
My
sir.
lord, fresh.
Take the steps, we'll see those two.
My lord,
Yes.
sir, the urgency is that the wife has filed execution petition, my lords. We filed RPSC of the year
Which
2000.
year is,
2000. RPSC of the year 2023, my lords, fresh now.
what were you doing without obtaining any order from 2023? And what is the urgency now?
Urgency is that NBW. has
Then
been
it
issued.
will be issued if you don't pay the money.
We paid.
We'll see. Yes.
Ladyship, may I mention,
My
Ladyship?
lord, 24, my lordship.
Hmm?
Fresh, 2020.
Hmm.
Ladyship, I'm appearing online.
1
Uh,
minute.
Sorry, Ladyship. Yes.
Yes.
Fresh matter, 2024 matter.
Fresh matter will come in the list. For that, no memo is required. Yes.
My lord, fresh matter, my lord, the urgency is that.
If it is, no, if the office objections are cleared, it will come. Yes. Yes. Page wise.
Page-wise adjournment, page 1, seal
That's-
number 2.
The,
Lords.
in the arbitration suit, the lower court has ordered for 100% and 9% interest method. It may be taken on Monday, not tomorrow.
Which year?
This is of year 23.
Will not be taken up. But there are so many other matters.
That's it may be posted on Monday,
Why?
because they have moved the execution petition. That is why we are moving the court.
Take the slips, we'll see. Yes.
My lord, it is interim extended memo, my
Huh?
lord. Interim extended memo,
It is a-
2023. Sorry, interim order extended memo. Day before yesterday, we are posted memo, my lord, but it is not posted.
Extension of interim order, when is it expired? Verify and tell the court officer. Yes.
But date was
Okay.
fixed, my lord.
Huh?
Date was fixed, my lord. 6/8, the matter was not listed, my lord, hence.
Verify that Anita, why it is not listed. Yes, call the page.
Page, page-wise adjournment, page 1, seal number 2, page 2, seal number 3 to 5, page 3, seal number 6 to 8, page 4, seal number 9 to 15, page 5, 16 to 18, page 6, seal number 19 to 24, page 7, 25 to 31,
Serial number 27, my lord. I am for the respondent. I intimated with the petitioner, my lord.
Why I think it earlier also it underwent adjournment.
My lord, I have not filed the assessment liabilities also. my lord.
Why should we adjourn this matter
No, my lord. Next week, my
2019
lord.
like that?
Not that, my lord. I contacted her, but she is not available. So I came to know that some of relatives have died. Kindly after next week, my lord.
You have an order, you have an order in your favor.
No, my lord.
You are refusing to.
Interim order is there already, my lord.
20,
Next week, any date, my lord.
27, you are for the respondent.
Yes, my lord.
I'm for the petition.
Pose this matter on September 3rd.
It's kindly extend the interim order, your lordship.
Interim order earlier granted is
Please,
extended.
Obliged.
Yes.
page number 8,
My lords, serial number 30, my lords. The other side, the council has refused to take the notice. So kindly permit us to send it through RPD, my lords.
30. In this registry is directed to issue emergent notice to the respondent, yes.
seal number, page number 8, seal number 32 to 36, page 9, 37 to 41, page 10, seal number 42 to 44, page.
My lord, 43, my lord. Adjournment for 2 weeks is required. Serial number 43.
Non-filing of statement of assets and liabilities
Yes,
by order dated 26/7/2024.
2 weeks.
Not filed.
No, we are trying to collect some documents from the court
Or for the
for the
petitioner,
petition, my lord.
interim order is there.
Order?
Interim order is there.
Yes, my lord.
Pose this matter next week.
2 weeks, please. Okay,
Yes.
it's obliged.
Seal number, page number 11, seal number 45 to 49,
My lords, leave item number 46, my lords, I appear for the respondent. Matter, my lords, has been argued.
My lords, there are few documents, my lords, which I intend to place before your lordships to assist your lordships in the matter. May I request my lords to have it on Monday, my lords? I appear for the respondent. There is an interim order, my lords, in favor of the petitioner. Lordships may kindly have it on Monday,
What's this matter on Tuesday?
46. I'm very grateful.
Yes.
Page number 13, serial number 50, 51. Page 1. serial
Yes,
number
what do you
1.
want? Yes, Mr. Kapoor.
Leadership, we had mentioned the matter on the 1st of August, the child custody matter. Leadership had fixed it for 6th on Tuesday, but it did not come up on the 6th. So my colleague is there with the memo. We requested if it can be taken up tomorrow.
It will come. It will come. Some other date might have been given for that. It will come.
Leadership, we
Yes.
checked with the board branch that there was no date mentioned. We request if it can be taken
What
up
has
tomorrow.
happened to that? The other day, they wanted it on Tuesday. I said it should be on Tuesday.
Yes, leadership, at 6 on the 6th.
Yes.
Serial number 1.
So
Nagaya
leadership, can it be taken up tomorrow, leadership?
We'll verify if it's there. Yes.
I'm so grateful. Thank you.
Yes.
Serial number 1. Nagaya for appellant.
I for the appellant in this matter, my lord.
Appear for the respondent.
This is the appeal arising out of the order passed by the reference court in LAC number 32/2014, which award was signed by the court on 26/9/2023. And appeal was filed on 15/11/2023, which is well in time. So my learned friend has raised the objection about the delay in filing the appeal. In his
To hear on valuation and court
please,
fees.
I will the valuation and another matter, another point was also there that about the limitation and all. For which I take this harm of court about the limitation that
No, before that, we'll go to this
Please.
valuation.
fine.
Yes.
I request your lordship to turn page number 79 of the ink page number 79 of the impugned order passed by reference court
Yes.
in 60, page number 60 of the reference court order.
Hmm.
This reference is partly allowed. Petitioner is entitled for enhanced compensation of rupees 9,46,342 in addition to what has been awarded by the land acquisition officer. See, this is the enhancement in reference court, in reference by the reference court. Whatever the award passed by the land acquisition officer, respondent number 10, has been paid to the respondents. They have received on 17/11/2023. And thereafter, they have filed the reference before the reference court. Reference court, after hearing the parties, has passed the award, enhancing the award above the reference court land acquisition officer,
How much is enhanced?
9,46,342.
Now, according to them, you have to pay the court
Yes,
fees on
we have
entire.
valued this, adding 12% additional market value for this, 9% 1 year interest and 15% for 672 days. It comes around 14 lakh and odd, upon which you have valued the appeal memo and paid the court fee. Office did not raise the objection about the valuation and court fees paid by the appellant. It is a respondent who made the objection before the court stating that the valuation arrived by the appellant and court fee paid by the appellant is insufficient and to hear by the Samba court. This is our submission.
Yes.
The total compensation awarded by the reference court and the SLAO, my lord, is 1,37,54,975. Less, my lord, awarded by the SLO is 38,01,370.
Where are you reading that? I'm looking at page 86.
My lord, I am reading from the memorandum of calculation, my lord.
No, well, let's see, let's look at the award. That order passed by the reference court.
Page 85.
85, yes.
My lord, there is some mistake. My lord, if your lordship permits, my lord, I'll place certified copy before your lord.
Take it.
My lord, one enhanced award, 9
46,342.
Yes.
2,83,900 total, 12,30,244. Then my lord, interest is stated. My lord, then total is 35,25,576. Then my lord, award passed by LAO, 36,92,123. Solatium 30%, total 47 lakhs. Then my lord, interest is one. Then finally total is 1,37,54,975. Less amount received, that is my lord SLAO, 38,01,370. Balance my lord is 99,53,605.
After deducting the amount which you have already received.
Yes.
Hmm.
So my lord, my submission is court fees required to be paid on this amount.
May I draw the attention of your lordship in respect of order of the Samba court dated in the appeal memo 9/7/2024. Nine seven 2024.
Oh.
Learned counsel for the respondent has drawn the attention of this court to memo filed on 2/4/2024 and order of even date would submit that respondent are disputing memo of valuation by appellant and alleged payment of deficit court fee. Though the dispute regarding valuation and court fee is raised, registry has not raised any objection regarding valuation. That is accepted by the registry. So whatever the valuation we have made and paid the court fees, court has satisfied.
No, now he is making the
No.
submission.
The-
Please on that, you please.
I will take your lordship.
No, you simply said it is 9 lakhs, but that is not
Yes,
so.
yes, it is that award, the decree of the court should not should be in consensus with the award passed by the court. The award passed by the court, why it is order dated, that is 26/9/2023, as I read in paragraph number 79, 9,46,342. Decree should be in consensus with this and not the decree as my learned friend has read now.
No, according to you, what was the amount granted by the land acquisition officer?
Land acquisition officer was granted the award 34,78,888.
What have you received from the, what is enhanced amount?
Enhanced amount is 9,46,342. Over and above the land acquisition officer award.
No, for the solatium and other things, where is the question of court fees on that? How, let us see under what provision?
My lord, section 48.
Yes.
Word, that is said.
May I request your lordship, kindly have it at 2:30, my lord, I will place a decision also, that's a division bench. judge.
Yes.
I request your lordship, then have the matter tomorrow.
Please.
Oblige.
Tomorrow. my lord.
Tomorrow.
Cell number 2.
But okay. Request your lordship, in this matter, interim order granted by the Samba court required to be
It
extended.
is there, extended by till
But-
tomorrow.
My lord, may I make one submission, my lord? In all other matters pertaining to this notification, 50%, my lord, there is a direction to deposit, except in this.
We will,
Even the division bench has observed that 50% is.
Tomorrow we'll see.
we will demonstrate it how they are not entitled.
Please.
Cell number 2, for admission, Shivacharan R, for appellant,
For the
Tebba Susan,
Lord, the appellant being aggrieved by the order.
What is
dated-
this MPA? MPA means?
MFA, MFA.
MFA. No, in the list it is no, within brackets, some MPA is there.
This election petition, my lord. We are challenging the order passed by the,
What is that short, what is that abbreviation MPA?
it's
But show me the list.
miscellaneous.
Can you just clarify that?
Huh?
Even we are hearing for the first time, can you just clarify
Yeah.
that?
I'll clarify.
No, here within brackets,
Officially, NPA.
it is, for the first matter, it is LAC land acquisition case. Next is MPA. Karnataka.
Municipalities Act, that's MP stands for Municipality Act. This petition has been filed by the respondent before the trial court under section 21 of the Karnataka Municipalities Act, challenging the election of the appellant before my lords.
Yes.
That's
No,
why
the return candidate, my lord, is before lordship as an appellant.
Hmm.
Lord, the order is dated 27th April 2024.
Hmm.
Wherein, my lord, I'll just first read the operative portion, my lord, which is at ink page 31, my lord. What's got it, my lord? 31. The petition filed under section 21 of Karnataka Municipalities Act 1964 is hereby allowed. It is declared that the election of the first respondent, Samiullah, son of
Yes.
so and so, not the respondent is the appellant here. Not he was the returning candidate who had succeeded in the election, and that has been, my lord, reversed, and the respondent number 1, who was in second, has been declared as elected.
Yes.
My lord, the facts, my lord, is on 2/5/2019, my lord, the state government issued order to hold municipality elections, my lord. On 9/5, my lord, notification was issued for the post of councillors. On 25/9, my lord, elections were held.
When is this order passed?
My lord, 27 April 2024, my lord.
Hmm.
And thereafter, my lord, on 31st May 2019, my lord, the results were declared. And, my lord, the appellant herein was
No, I didn't hear the earlier one. When is the election notification?
election notification, madam, 9 May 2019, my lord.
Hmm.
Elections were held on 29th May 2019. 19.
No.
29th May 2019 was the date of the election.
Hmm.
My lord, 31st May 2019, my lord, elections results were declared.
Hmm.
And, my lord, the appellant herein was declared elected.
Hmm. Hmm.
My lord, subsequent to the declaration, my lord, the respondent number 1 filed the election petition, which is now been under question.
When was it filed?
In the year 2019, my lord.
Hmm.
Within 15 days, my lord, as per section 21 of the Municipality Acts. There is no dispute, we are not disputing the time frame. My lord, the only ground what they're saying is, my lord, in the affidavit, appellant has failed to mention a criminal pending case, which was, my lord, where appellant was one of the accused. And that flaw has resulted in corruption of corruption practice, my lord, as per section 23 of Municipality Act. My lord, I would like to read the reasons, my lord, if you can permit me.
Starts from which para?
19, my lord. The counsel for petitioner have eminently argued that the respondent would have not furnished the correct information with regard to pendency of criminal case, and also written the name of one Samana Tabasu.
With the act. Act.
Okay, he's reading this one.
Yes, please read.
Yes. In the affidavit annexed with the nomination. On the other hand, it is the contention of the respondent 1 that the petitioner himself has also not furnished correct detail with regard to pendency of the cases against him, and there are no grounds apparent in the petition to allow the petition. Lord, even the appellant herein at counter filed objection, wherein, my lord, the respondent 1 had also failed to mention a criminal case pending against him, my lord.
Yes.
In order to prove the case of the petitioner himself examined as PW1 and got marked exhibit P1 to P14, exhibit P1 so and so, my lord. The next relevant portion, my lord, would be para 15, my lord.
Yes.
Page 11. Exhibit P1 is the letter written by the petitioner to the returning officer stating that the respondent number 1 has furnished false information to his nomination and there is a case pending against him in CC number so and so.
for the offences punishable under section 143, 144, 148, 323, 506, 149 of IPC, and the same is punishable with the punishment of more than 2 years. Hence, by virtue of said application, as prayed to reject the nomination filed by the respondent 1. Returning officer has issued endorsement as per Exhibit P3 to the said application, stating that the verification of the nomination was started at 11:37 a.m. and completed at 11:46 a.m. And in spite the petitioner being present, has not objected orally or by submitted the letter, and at 1 p.m. has given application. Therefore, the question of considering the nomination or to revisit the same does not rise. My lord, thereafter, my lord, I would like to, my lord, read para 18, my lord.
Yes.
During the course of argument, the counsel for the respondent 1 has vehemently argued that as per Exhibit R1 and R2, there are no other cases pending against the petitioner, which is not only disclosed by the petitioner. As such, the respondent 2 has rightly rejected the nomination filed by the petitioner. But the respondent, but during the course of cross-examination of RW1, he deposed that he did not file any objections to the respondent number 2 with regard to cases pending against the petitioner, and the said fact falsely the contentions of the respondent number 1. Further, it is argued that the present petition filed by the petitioner is not supported by any affidavit disclosing the fact as to corrupt practice adopted by respondent number 1 during elections as per section 81 of RP Act, and relied upon the order passed by the Honorable Apex Court in civil appeal number so and so between A. Manu versus Prajwal Rivana and others. I have gone through the said orders wherein the non-filing of affidavit by disclosing the corrupt practice was in question. In the said case, the parties were contested for the parliamentary constituency elections in the year 2019, and the court held that filing of affidavit disclosing the corrupt practice is mandatory. Whereas in the present case, only municipal elections are in question, and the same are governed with municipal rules and not RP Act. As such, the date decision is not applicable to the case in hand. Next paragraph, 19. Even the counsel for the respondent argued that Exhibit P8, there is no mention as to whether the case is registered by the police or it is a private complaint. And
So that's the only ground.
yes, ma'am,
No,
that's the only ground.
you'll ever counter allegations against the petitioner saying that he has not disclosed certain
Yes, ma'am.
things.
There
Which
is
the
one
court has
allegation.
said that there is no
Yes, ma'am.
evidence for that and pressed it.
There is one difference here, my lord. The case where, my lord, the appellant was arraigned, my lord, there the charge was not framed. My lord, in the year 2019, in the month of, my lord, April, he appears, seeks bail, and for 2 weeks thereafter, my lord.
So that is it is even your case that it is a private complaint that is given. That's why you're not even aware of registration of the complaint
Please,
is
ma'am.
one.
Yes, ma'am.
Second, when you have obtained the bail, where is the question of you not knowing about the registration of
Within
case?
2 weeks, my lord, prior to the nomination, my lord, 2 weeks prior, a bail was obtained, my lord. Thereafter, my lord, the nomination was filed. By oversight, my lord, this has not been disclosed.
Is it law that only after the charge
Yes,
charge
ma'am.
sheet is
No,
filed,
I
then
just
only?
rely upon, my lord, the order passed by our High Court, my lord.
No, let's look at the provision first.
Yes, my lord. Before that, my lord, the trial court has held that, my lord, the Representative of People Act will not be applicable, my lord. It is not so, my lord. When it comes to corrupt practice, my lord, it has not been defined in Municipality Act. Lordship may kindly see Section 23 of Municipalities Act, my lord.
It is an interlocutory application at that point of time
Please.
where that particular issue is raised.
Please, my lord.
On that, a finding is given by the court then and there in the IAC.
Yes, my lord. Reasoning was given, my lord, and that was.
Never questioned.
No, my lord, that's not the issue.
So now we'll not go into that.
Please, my lord.
So come to section 21. What is?
No, my lord, with respect to
this is
corrupt,
filed under
my
section.
lord, with respect 20, yes,
21 for practices under section 23.
Mills.
Lord, with respect to corrupt practices, my lord, there was no IA was filed, my lord. Lord, this issue was not raised, my lord, only the statement of objection was raised, not as separate application, my lord.
No, we'll lead
21, my lord.
Yeah.
Yes, ma'am. Election petition. No election of a councillor shall be called in question except by an election petition presented to the election tribunal within 15 days from the date of the declaration of the result of the election. Lord, that is not in dispute, my lord. We are not saying with regard to time limit. Lord, we have raised one my lord, ground here is with respect to 21 subclause 3. Misjoinder of my lord party. A petitioner shall join as respondents to his petition all the candidates at the election. My lord, whereas here he has arrayed, my lord, the returning officer as respondent number 2 in the election petition. My lord, that ground was urged before the trial court, which was not considered by the trial court. My lord. The misjoinder as per section 21(3) was not considered by the trial court. My lord, now 23, my lord. Grounds for declaring election to be void. My lord, the only ground what they have urged is corrupt practice, my lord. Non-disclosure of a pending criminal case will not come under the definition of corrupt practice, my lord. Is my humble submission. My lord, 23A, my lord, that on the date of his election, returned candidate.
What is the complaint registered against you?
My lord, under section 143, 144, 148, 323, 506, my lord. And he's one of the accused, my lord. He's nowhere connected.
Well, that's a different.
Yes, my lord. Trial is still, my lord, pending. Yes, my lord. The question here is, my lord, whether charge was framed only because he has arrayed as accused, my lord, he can't be.
It is only disclosure of the correct statement and the facts.
Please,
It is not about whether a complaint is registered against you, whether you will be disqualified from contesting the election. It's a separate issue, is
Please,
it
ma'am.
not?
Yes, ma'am.
Are you not supposed to say that if there are any complaint, there would be a column or?
Please, ma'am. But this honorable court has held that until the charges are framed, the disclosure of pending, it's not mandatory, my lord.
Let's see,
I
where is
see.
the judge? So what does the form contain? What it contains?
Form, my lord.
Oh.
That is there.
That's the trial
Did you
court,
get it?
yes, the trial
yes,
court
ma'am.
records have been summoned.
The LCR, my lord, lordship will find it.
And I think even in the petition, I think they have enclosed it.
No, not in the petition.
The LCR may be seen, it's the trial court records.
Exhibit P4.
Exhibit?
P4, my lord.
Because it's in Kannada, mother.
Now what it, please read that. Which is column number? This is P3. You said exhibit P4.
P4, my lord.
Not here. And you read, what is that, what it says?
Just says that mother side. Yeah. No. Which column it says? The bacon.
Election form.
I'll take it.
The judgment, it will be there, no, where it said that there's no criminal case. That's in that form, that's it says Baga Feet. It's there. Sorry. It's a 7th column, that's 7A.
What it says?
It says Anvay Suitilla, meaning he's saying that none of the criminal cases not applicable. He's saying if any criminal cases are pending, he says not applicable. It's a typed copy and.
It's only criminal case is pending. If any
Yes.
criminal
Yes,
case is
ma'am.
pending.
Yes.
So according to you, as per the judgment, if a charge sheet is not filed, it
Charges,
cannot,
my lord, charges.
charges are not framed,
Yes,
you
ma'am.
can't consider it as a criminal case.
Yes, they can't arrive, my lord, as accused.
No, it is not about, it didn't say that you are, whether you are an accused or any criminal cases are pending against you.
Yes, my lord, the declaration, my lord, in the affidavit is not mandatory.
Is?
Not mandatory.
No, that's what in a language that is employed in the application, what is it? Any criminal cases pending.
Yes, my lord.
It didn't say, it didn't use the word accused, or it didn't use any other word.
Please, ma'am.
Just said, no, next question is, unless and until whether you can be disqualified or not is some other aspect.
Please, ma'am.
Like, or the judgment, whatever you say. When it says, whatever it is, you have to disclose it.
Please, ma'am.
That you have not done.
Is not done.
Please, look, I will pass on the judgment.
First put in.
This one, Justice Krishna Dixit.
Please, please, madam.
Let's see.
Lord, page 4, my lord,
Yes.
this provision,
What is invoking the revision?
I'll just read the observation.
There has to be a bail application. That's. Rejection of a bail application, which is common question.
Wherein, my lord?
No, it is arising out of which order?
Lord, arising out of order dated
That's
11/11,
page number 2, my lords.
2023, my lord.
Page number 2, it says petitioners invoking the provisional jurisdiction of this court under section 297.
397.
397, Red 401 of so and so. Calling in question the Sessions Judge's order dated 11/9/2023.
Dismissing
Dismissing criminal appeal and thereby confirming the order of conviction and sentence made by learned so and so. So it's against an order methods where conviction and sentence has been confirmed.
Now, here it is under, he is accused of any offense punishable with imprisonment for 2 years or more in a pending case in which, that's how basing on that
Please,
provision,
ma'am. Yes,
it is dealt with.
yes, my lord.
Then how it applies to your case?
Lord, even here, my lord, the provisions says more than 2 years, my lord. Punishment.
No, in that election, form, that nomination form,
Please, my lord.
what it says, it simply says nothing about, it only says any criminal
Case
cases
pending.
are
ma'am.
pending
Yes,
against
ma'am.
you. So are
He
you
has
not
declared
supposed to
not
disclose
applicable.
it or not?
Yes, my lord. He has declared as not applicable, my lord.
How can it be? There is a criminal case pending against you.
Please, my lord.
That is, you have not stated the correct, on affidavit.
Well, the reason, my lord, is, since the charge was not framed, my lord, there was not,
That
not
kind of an
mandatory, my lord.
interpretation is not, let's see.
And,
what
and,
is-
and
what the
also, my
learned
lord,
judge
no,
has
and
done.
also, my lord, the ground what they are urging is, my lord, corrupt practice. My lord, as per Municipality Act, my lord, there is no definition for corrupt practice. So, my lord, therefore, we have to rely upon Representation of People Act, section 123, my lord. For a moment, my lord, Lordship, I kindly see, what exactly is the definition of corrupt practice? Lord, the ground what they are urging is corrupt practice.
So no.
Whether non-disclosure, my lord, whether
No,
non-disclosure.
on the first ground with regard to, because charges are not framed, you are not an accused.
Please.
That ground is now clear. That as far as that application, that nomination form is concerned, there
Yes.
it prescribes about any cases pending.
Please.
It's only a simple information.
Pending or
which-
filed minutes.
Pending or filed.
Please.
So you have not disclosed. That is one aspect.
Yes, my lord.
Now next is, now we'll go to that.
Reason why not disclose it, my lord, this, my lord, ruling says it's not mandatory to disclose it.
No, how can a judgment say something when this language is so simple?
Yeah.
There is no question of,
I'll establish.
there is no question of
I'll just
interpreting
read,
that.
my lord, I'll just read the,
That this was interpreted in the light of section 13(3)(a).
please, my lord.
Now we are on your nomination that is
Yes,
filed and whether
yes,
you disclose the facts or not.
Please, my lord.
That says you have not disclosed.
Correct, my lord.
Uh.
In the reasoning, my lord, and the observation, my lord, this honorable court has held that Once, my lord, only subsequent to the framing of charges, my lord, then the declaration might be mandatory. Prior to that, my lord, the candidate need not declare.
Then what is, according to you, what is the purpose of that column?
Yes, my lord. And, my lord, the main ground what they're urging is, my lord, corrupt practice.
Then now we'll go to that.
Please, my lord, I'll
Yes.
come. Section 123, my lord, of RP Act, my lord.
Section?
123.
Yes. Later. Yes.
That's what it means.
Hmm.
The following shall be deemed to be corrupt practices for the purpose of this act. Number one, my lord, is bribery. That is to say, any gift, offer, or promise by a candidate or his agent or by any other person with the consent of a candidate or his election agent of any gratification to any person whomsoever with the objects directly or indirectly of inducing a person to stand or not to stand as or to withdraw or not to withdraw from being a candidature at an election, or an elector to vote or refrain from voting at an election, or as a reward to a person for having so stood or not stood, or for having withdrawn or not having withdrawn his candidature, or an elector for having voted or refrained from voting. The receipt of or agreement or receive any gratification, whether as a motive or a reward, by a person for standing or not standing as or for withdrawing or not withdrawing from being a candidate, or by any person whomsoever for himself or any other person for voting or refraining from voting, or inducing or attempting to induce any elector to vote or refrain from voting or any candidate. Two, undue influence. That is to say, any direct or indirect inference or attempt to interfere.
Yes, I've seen that.
Yes, my lord. But therefore, my lord, the ground urged by the, my lord, the respondent one is that the appellant herein was involved in corrupt practice, my lord. But the definition does not disclose whether, my lord, affidavit, there was any flaw in the affidavit. So therefore, my lord, the provision will not be, my lord, applicable in this particular case. My lord.
We'll ask him.
Please, my lord.
Yes.
That's to the pointed question, Millards, and the argument. May I just rely upon one judgment on the exact point, Millards?
With regard to corrupt practice.
No, with regard to existence of a case, whether it should be disclosed or not, Millards, was dealt by this court. And Millards, another issue also which is being.
But
That
no
Millards-
judgment is
Yes,
required.
yes, yes.
It is no, when there is nothing to interpret there.
That's for my satisfaction. That's page
Yes.
number 10, paragraph number 9.4. In this case also, Millards, a similar circumstance which existed. Millards.
Yes.
Page number 7, Millards, three
Yes.
issues were made.
Hmm.
Whether in a nomination form. That's all.
Hmm.
Whether in a nomination form filled by a candidate, the candidate could have to disclose criminal proceedings in which the candidate has been acquitted or not. Now, Millards, the answer to it is at page number 10, paragraph number 9.4.
Yes.
The mere fact of filing of a complaint in criminal proceedings would suffice for such candidate to disclose the same in his nomination form. If there is no particular row, this is in a case situation, or that's in this case, they argued saying there's no space. So how would I disclose it? That's the answer to that, Millards, in this judgment is if there's no particular row or column in the said application to enable disclosure, or if the space available is less than what is required, such candidate should always make use of additional sheets to disclose the particulars like the crime number, provisions under which the allegations have been made, who are all the co-accused, who is the de facto complainant, the stage of the case, if pending, nature of disposal, date of disposal, if an appeal is filed, and the details as regards appeal, if proceedings have been quashed. The second issue, Millards, came into picture was whether it is necessary to find out or give an observation. Now, this would answer my lord's question of the word corrupt practice. Would it materially affect, leaving apart the word corrupt practice, Millards, would non-disclosure affect the election or not, Millards? the answer to that question, my lords, would find it starting from page number 12, paragraph number 10.3. The finding is at 10.5. On comparison with the facts of the case, my lords, 10.4, I may start reading this.
Yes.
One other fact that is to be considered is that the petitioner led his evidence without objecting to the non-framing of issues. Thus, were no impediment for petitioner to lead evidence which had been done so. Hence, this issue cannot be raised. 10.5. Hence, I answered point number 2 by holding that in the present case, non-framing of issues or non-formulating of points for consideration before evidence did not vitiate the proceeding. The third one, non-formulation, would it affect the entire case of the petitioner before this court or the appellant before this court? That answer, my lords, is at page number 15, paragraph number 11.2. In essence, my lords, the contention of the appellant today before my lords is that the word corrupt practice is not defined under the Karnataka Municipalities Act. However, it has been elucidated or explained in a detailed manner under the People's Representation Act. And that should be taken into account when I am seeking for, or the court, while it is invalidating a particular election. That's the answer to that, my lords, respectfully. The court has to consider as to what has to be essential when a person is contesting for election. Now, my friend read paragraph number 18. Now, my lords, what he forgot to read is paragraph number 16 and 17. My lords, as basic as the name of the person who's contesting the election was not written, my lords. My lords may turn to paragraph number 16 of the judgment, which is at page number 22. 16 talks about, my lords, him having obtained a bail, which, my lords, learned friend reasonably agreed to it, saying 2 weeks before the nomination. That's my turn to paragraph number 16. That's at page number 22 of the appeal memorandum, which talks about methods having knowledge of the bail. That's paragraph number 17, which is very crucial, methods. Methods, it is like seeking for an admission of a person without even mentioning the right name of the person. Methods may permit me to read paragraph 17. The counsel for the petitioner during his cross-examination also elicited in exhibit P4 at page number 7, the name of one Shabanam Tabsam.
Now, before you go into this, you filed a petition under section 21.
Yes, methods. For practices under section under the grounds of 23 methods.
21(3).
No, petition is filed under section 21 for the
Grounds
grounds
23.
which has been urged under section 23.
23. So how do you say that it is a corrupt practice?
Please.
The
That is-
suppression of a material fact itself, my lords, would amount to a corrupt practice.
Where is it defined?
That's
Where is it defined that non-disclosure or disclosing a wrong fact?
That's, I just relied upon a judgment to show that non-disclosure of this particular fact. That's even that petition, methods, was alleged on the exact same ground of section 23(1)(b) of saying that it's corrupt practice. The word corrupt practice, it's evolving. I give you, I may be permitted to give an example. They can be a corrupt practice which once upon a time might be physical distribution of money once upon a time. Now, there could be another
No,
instance
what
where
is
they
a
are.
corrupt practice even under the
RP Act.
RP Act also? In
There's a
so many
definition.
ways, it has been explained elaborately what is a correct practice.
I may be,
Disclosing, non-disclosing the correct fact would amount to
suppression of
corrupt.
facts.
Whether, that's
That is
what,
the
no,
ground
when
order.
you're
Yes,
seeking,
it is. I can.
seeking, when you're filing an election petition under section 21, underlying on 23, the grounds on which, so that particular ground which you're raising should be formed part of any of it. Is it not?
I understand.
So let's see whether one of it, definitely that corrupt practice, non-disclosure is not, it is saying something, not being true to himself or not on oath,
Would
saying
it make a
false
material
things.
difference, That's the object of section 23. I will allow me to satisfy on this point. The object of section 23, where they say grounds for declaring election to be void, is to go on to say, even if it's clause A, B, C, or D, or even 2 or say a
No,
subsection.
no, if that is the case, everything which is not right, you can file an application.
Sir,
That's not.
I
When
come
they have
to that.
given as many as A to one, one A to D, or again, there are so many grounds that are enumerated here, it should form part of
Please,
it. Or at least from one clause, you should be able to say, corrupt practices, in the opinion of this court, subject to what you
I
say,
understand.
do not
I will
form
have to
part of
convince
this.
I will have to convince my lords on the point that suppression of fact
Amounts to corrupt practice.
amounts to corrupt practice. It is dealt in Kanimori case, in 2023. As of this minute, I do not have a copy of it. May have it tomorrow. I'll produce the judgment and I will
Will
satisfy.
have passed over anyway, I heard it. If you,
There's other matters.
so the difficulty is now again, we have spent.
No, I will only take not more than a minute, tomorrow morning.
Only on that.
Only on that.
If that is, if it is not there, then we don't find any grounds
I leave
under
it to my lords.
21 or 23.
But my respectful submission is, my lord, the corrupt practice as per RP Act, my lord, the definition is clearly described.
Yes,
What exactly is the corrupt practice?
yes. Tomorrow,
Yes.
Great.
at the request of the land council, post this matter tomorrow for the respondent.
I may seek to have it on Friday,
Friday not.
Monday.
Yes.
Monday.
Great.
Only on this point, I would not take much time. Monday.
Monday.
Monday. Monday, no?
Yes.
Grateful.
Till number 3,
Grateful.
till number 3. Preliminary hearing. Dilip Kumar, Mega Chandra.
Challenging the order of the Honorable Family Court granting 10,000 maintenance to the wife and minor son, which is under challenge now.
Lord, on the last occasion, they have filed a memo of calculation. Lord, yesterday, my lord,
Every case, the court is hearing 10 times and every time it has to be again started.
can I dispose
I have,
of it?
no, I have not argued on merit in this case, but the other than.
Yes.
I take your honor the application in page 46.
You appear for the wife.
Why?
How much is intermaintenance granted?
10,000, madam.
According to you, what is the husband, what is the income of the husband?
About 3 lakhs.
What is the document that is filed
My
before the
lord,
court?
the account statement produced by him and the income tax returns filed by him, the gross total profit itself is 57 lakhs.
Hmm.
In the balance sheet, what he has
How
produced.
much you have claimed as maintenance? How
10,
much you wanted?
I have sought 50,000 for wife and 25,000 for son.
15,000 for wife.
50,
and
50, 50,
50 and 35. You sought for 85,000.
75,
Oh,
25 for son,
25. Then what is
15,000 for
what is the
wife.
qualification of the wife?
MBA.
What is she doing?
She is a housewife before marriage also, even post marriage also.
She should remain a housewife because
And
she's a.
having a small child in a one
What is
house,
the age?
a third standard child.
7 years.
Can I make sense?
Yes.
But in my application, I have sought 50,000 and 25,000 and also sought the arrears of the house rent, which initially the husband was paying because I did not give the divorce consent.
What was the MC file?
MC
20?
21.
Till what time he was paying the maintenance, the house rent?
From
2020. Till November 2020. Look, this is the third round of litigation.
Yes.
let it be. Till November 21, he was paying the house rent. When I refused, Your Honor, to give divorce, he stopped paying the rent and also stopped paying the school fees. That is what I was forced to file a domestic violence petition. It is pending. In that, there is no order. In this petition, I have sought for the arrears of rent because the landlord has issued a notice to evict me to pay, direct him.
How much is the rent?
The 9,500 at present.
Yes.
And also sought for direction to pay the school fees. Because, Your Honor, the husband has blocked my number. I cannot contact my husband. Whenever the school informs.
So right from 2021 till now, how much, what are the amounts that are paid by the husband?
No. Other than 50,000 in the last date before the family court, he has not paid anything. That too after passing of the order. He pay irregular school fees. That too after I filing an application. And only to take credit in the income tax return. That's what he is taking benefit out of his income.
Anyway, give him a benefit. You are also benefited.
Correct. So and also I have sought for the cost of the.
So for how many? When did he pay for which academic years he has paid this school fees?
19 he has paid and 20 he has paid. In 21 he has not paid completely, but 22 he has not paid completely. Half of he has paid. What he has produced the receipt. I've also produced my
3 and 24.
Now he has paid part payment and remaining payment he has.
23 also part payment.
23 also part.
Part means half of it.
Half means installment he is paying.
He is paying to the school or to the wife?
Directly to the school, not to me.
Then who is paying the remaining? She is paying.
What other extracurricular activities, everything that I have to both.
No, there should be a clarity. School fees is not extracurricular.
Correct.
School fees is school fees.
Correct.
Whether he is paying the school fees or not.
Now he is paying, Your Honor.
24 he paid or not?
Not half paid.
20, then half he will pay, then half the wife is paying.
Last year that.
Why the two school people will keep quiet if half is paid?
1 minute. Whenever he has not paid, when there is a force that I was forced to pay, Your Honor.
That's what I'm asking. So 21, you say half paid. So remaining half she paid.
Yes.
And 23?
23 he has paid. One term he has not paid, which I have paid.
Then 22?
22 he has paid.
And 24?
24 he has paid part payment. And there is a due is there from the school.
Yes.
So that is, I take, Your Honor, the affidavit. I have stated my husband is a civil contractor and his turnover is more than 1 crore. And also I have stated how many immoral property he owns by lot. The 10 houses he has been rented out, 4 commercial shops he has been rented out, and I have kept in a rented house. And which these fact, and also they want say one Kalyana Mantapa. That is also fetching a rent. All these facts were never denied in the objections. In spite of these facts were never taken into account by the lower court while granting the maintenance. And and also not considered that whether the arrears of rent has to be paid by the husband or not. Only granted 10,000 maintenance. If I pay 10,000 to the landlord itself, how do I survive? That is when husband is, as per the document, my lord, income tax returns, Your Honor, the 57 lakhs he has shown. I say, Your Honor, he has not shown fully because as per the document present before the court, Your Honor can come to a conclusion. His income, turnover is more than 1 crore and above, admittedly. I have produced the account statement from April to August 2022. The total receipt is 57 lakhs. He himself has produced yesterday one account statement. for the whole period of the 2022 is the total receipt is 50 lakhs something odd. If I calculate up to August 22 and the another bank statement would hit the total receipt is more than 1 crore 7 lakhs. In his income tax returns, he has suppressed the account statement of the other account statement. Only he has shown the one account statement before the income tax returns for the purpose of filing of returns to evade the tax, Your Honor. As held by the Apex Court in 2022 ballot, the income tax return is not a one ground to decide the parameter of the maintenance. And other also it has to be taken into account. And certainly the husband will evade to show lesser to evade the payment of maintenance to the wife. So when a husband is earning rental income of more than 10 houses and 4 commercial shops, and his turnover is more than 1.5 crore, approximately, if they produce the up-to-date Your Honor can see from 1/4/22, this is pertaining to Nigam civil consultant who is a proprietor. But he's a civil engineer, he did his MS in UK. And this account statement from 1/4/22 to August 22, I take Your Honor, the last page of the account statement, 24/8/2022. His total receipt in this is 57,08,580. This is the only account statement which he has shown in his income tax returns. The another account
Where do you get that 57 lakhs?
in the last, in the last
Page number?
21.
21. Your Honor may
Total
see
credit amount in the last
total
column.
credit amount, the 57,08,580.
Yes.
The next document, Your Honor, is income tax returns.
Yes.
In the second page, my lord, the second page of the IT returns. Kiran Arsegoda, he has given the account number to audit only Axis Bank account statement. This
What
account,
is this bank?
this is a Canara Bank. This was not subjected for the income tax returns. He has only given the Axis Bank account statement
Where do you get that?
in the the second page itself. There is the account number, name of the bank, Axis Bank, account number, it is mentioned. In this, Your Honor, he has not taken into account the amount created in the Canara Bank. He has.
Has he filed this account before the trial court?
Yes, this is his own admitted document, whatever he has produced, that I am producing here. So why I am trying to say, Your Honor, he has not fully disclosed before the income tax authority his account, how many accounts he owns, and what is the total receipt. The 4480 says whatever the total gross receipts are there. If the gross receipt is taken into account, it would come more than 1.5 crore. If that is says, if the 8%, he has declared that the 14% is the profit. Your Honor, in the same line, the second page, profit under section 44 AD, Nigam civil consultant is profit deemed under section 44 AD is 8%, 57,03,000, 8% he has only calculated. The law says only because you do not maintain the books of accounts, is the minimum amount what you have to declare 8% is the profit. Only now the government has made it up to 3 crore. So you would no necessity that you have to maintain a books of accounts. Does not mean that only profit is 8%. It is only for the income tax purpose to declare, that's it. In the next line, Your Honor, profit declared under section 44 AD at the rate of 14.26. He himself has declared the 14.26 profit. The law says 8%. He himself has declared 14.26. If that is declared for the whole amount, what he has received from all of his accounts, Your Honor, would have been not this 8 lakh, would have been more than 20 lakhs. So why I am pressing to prima facie shows before this court at this juncture with his own document, his income, what is reflected in the IT returns is only for the sake of filing.
Yes. Next.
The next, my lord, the 3 years, his IT returns he has submitted, every year there is an increase of the income. And also the receipt what he has produced, that also I have produced, not by me, whatever he has paid that I have produced. The photos what I have produced, Your Honor, is the photos of the houses what they owns.
Were these photos filed before the trial court?
Before the court.
What is the response to this?
No response. They have not even denied. They have not even objected. I take, Your Honor, the objection statement and also my application, my lord, in ink page 46 of the petition. 48, my lord.
48 of what? 48 of the writ petition.
Writ petition. If you want, take it from the 47, para 2, para 3. Affidavit, my lord.
Yes.
I found that the petitioner completed his BMS in UK and was working as an assistant professor in AIT College, Hasarghatta Main Road, Bangalore.
I've seen that you have mentioned about the houses.
I have mentioned
Where
the
are the
details.
objections?
In the objection, in the next page, in page 53, my lord.
So in reply to para 3, what did they say?
They have not denied. They have not whispered anything. But in the cross-examination, they have admitted it's all fetching rent.
They admitted?
It's all fetching rent, it's all given, rent it out. So these fact of the houses, the lower court says that I have not produced. Where the husband do not dispute these averments, Your Honor, the court will ought to have taken into consideration that the averments made in the petition that he is getting rent from his share is more than 2 lakhs, Your Honor. And his income,
Yes.
what he has stated, the 56 in his asset and liability statement, Your Honor, is false. Prima facie, it is evident, Your Honor, his income is more than 3 lakhs from his the employment. So a contractor, Your Honor, that's what the apex court said, the reported judgment, my lord. The same situation where is a contractor. Putidra. The second page. It is an admitted portion that the second respondent worked as a contractor. While the second respondent claimed in the above proceeding that the first appellate was unable to maintain the minor children, he had failed documentary evidence about his educational qualification. In para 10, my lord, on the first aspect, it is well settled that income tax returns do not necessarily furnish an accurate guide of the real income. Particularly when the parties are engaged in a matrimonial conflict, there is a tendency to underestimate income. Hence, it is for the family court to determine on a holistic assessment
Yes,
of.
I've seen that. I've seen that. Yes, please.
Lord. Petitioner, my lord, in their statement that is produced before the family court, the total turnover in their account is more than 22 lakhs. They have a wine business, that is bar and restaurant business, which is fetching her almost 45 to 50,000 a month. There is a 21 lakhs which is undeclared from her account. And she has sufficient means to maintain herself through her family property. And so far as the photos produced, my lord, they are the properties belonging to my father and my mother independently. That is not an ancestral property for me to have a.
So why you can't reply to that? When they have stated it in their statement, when you're filing objections.
By inadvertence, I have missed out in my statement of objections, my lord, but it was addressed to the court. It was considered by the court.
Yes.
And so far as my lords, so far as the school fees payment is, my lord, it is up to date, paid by the respondent himself. If they claim to have paid any of the school fees, my lord, let them produce the receipts to that effect. Whatever the other expenses that they claim to have paid. And so far as the rent is concerned, my lord, the rent was fixed at 7,000 and gradually it was 7,500. Now they are claiming up to 9,500, my lord, for which the landlord has not approached me also so far. If that is the case, my lord, let them show to that effect that the rent itself is 9,500. I will make necessary arrangements.
I am transferring to her account, my lord. The 500 every year they increase. It is not the stagnant, my lord, the rent.
Please come.
And my lord, one last submission.
Yes.
Let there be a specific direction, my lord, to the family court, my lord, to conclude.
Provided whatever now the court is going to give the maintenance that you pay.
And my lord,
With the arrears.
one further request, my lord. This petition is filed in the year 2021. 2022, it was set on for cross-examination of the petitioner, that is the
My lord,
respondent.
there is already a direction from this court.
Wait, Mr. Counsel.
It's 2022, my lord, till this day, they have not been cross-examining. my lord. And
That's
that-
what,
and
all this now, in spite of an order from this court to dispose of the pending MC,
Please.
now unless and until the arrears, now what now by this order, what the court is going to pass.
For the mistake that they have committed, I should not be blamed. From 2022, it was set on for cross-examination, my lord. For that period, my lord, my maintenance of
You're
whatever
also
arrears
supposed-
may be exempted.
Yes.
He wanted
When
to
is
prejudice in
the
this
order
way, my
passed?
lord, that's it.
On 27th March 2024.
The order is passed on March 27.
Then,
Please.
yes.
But the order is
Anita.
from the date of application,
Not from the,
not from the date of the order. The order is
that is also in question by him.
to pay the arrears from the date of application, my lord, from the date of.
But we will
Arrears
clarify
has
now,
to be
but
paid.
it is from the date of application.
The application.
From the
is
date
given
of application,
My lord, the maintenance has to
The
be
date of
granted from the
application.
date of the application.
date of application. 2022, when the matter was set down for cross-examination of the respondent.
yes.
From
From-
there, they have been delaying, you know, on one or the other pretext.
Is it open?
My lord, the arrears of rent,
Dictation. No, there need not be any order for that, for arrears of rent. No, once you get from the date of your application, if you are getting the maintenance, that will also be part of it.
my lord, the arrears of rent, my lord,
That's what rent also.
That is not
There
aspect-
won't be a special component of rent. Now, determining everything, court will grant maintenance.
that can be
then that,
included, my lord.
The agreed with the
One
order.
last aspect. One last. Lord, they filed his application claiming maintenance on Lord 5/7/2022. That is for maintenance, for son's maintenance, for arrears of rent, and also for litigation expenses. Subsequently, again, after a month later, my lord, they filed another application claiming litigation expenses. What is this conduct?
Ask him. Agreed with the order passed in file number 5 and 6 in MC number 1225 of 2021 dated 27th March. It's not typing. March 2024. The wife is before this court. Parties are referred to as husband and wife for the sake of convenience. The petition herein has filed a petition seeking interim maintenance at rupees 75,000 per month and arrears of rent to pay the school fees of a son and litigation expenses of rupees 1 lakh. It is a case of the wife that the marriage was organized on 4/12/2013 and that of the wedlock, they're blessed with a male child on 9/4/2016. The husband had filed a MC on false allegations. In fact, she has been mentally and physically harassed with her husband. It is stated that she has also filed petitions under the Domestic Violence Act. It is her case that the husband has completed his BE MS and working as assistant professor in AIT College and is drawing salary of 50,000. He's a owner of several immovable properties. He has let out 7 houses and receiving rental income. She is paying school fees of a son who is studying at VVS Gandhi Central English School, Rajaji Nagar. When she has refused to give divorce, refused to give divorce, the husband has blocked her number and stopped paying the rent of stopped paying the rents. It is a case that though she is MBA graduate, as she was even before marriage or now, she's not working and she's not able to secure employment. The husband had filed his objections, stating that he is a civil engineer. He has suffered due to COVID, he had suffered massive loss. He has to pay loan of rupees 68,75,000 to Canara Bank. The wife is MBA graduate and she is a joint owner of Mrs. Sunila Wines. She is getting rupees 15,000 per month towards her share. She is a joint owner of 6 acres coconut field and getting income of rupees 5 lakh per annum. At the time of execution of rental agreement, the husband had paid rupees 50,000 to the owner as advance amount. He has requested the landlord orally to deduct the arrears of rent from the advance amount. After she filed the DVC, he stopped paying the rents. He undertook to pay 50% amounts to his son towards his son's educational expenses. No, it is the case of the respondent. It is a case of the respondent husband. Before that, no, right from this. he is a civil engineer and all. That's the case of the husband.
But these petition amendments are completely in suppression of material facts. All the petitions that I have filed and what she has filed has never been stated here.
50%, the husband undertakes to pay 50% of educational expenses. The court, considering the submissions on behalf of both the parties, had granted an amount of rupees 10,000 per month to the wife as well as the son as interim maintenance from the date of the application to the disposal of the case. And the husband was directed to pay an amount of rupees 10,000 towards litigation expenses. And he is also directed to pay actual educational expenses of his son for every academic year. He is directed to deposit the arrears of rent within 3 months from the date of the order. While passing the said order, the court had considered that the wife had not produced cogent material to show that the husband is owner of several immovable properties, including houses, commercial shops, and getting in rental income. She has not produced the documents to show that husband is the owner of Sri Lakshmi Venkateshwara Kalyana Mandapa, Amratur, Kunigal Taluk. Canara Bank and Axis Bank statement of the husband prima facie discloses that he is getting regular income and capable to pay reasonable maintenance to his wife and son. The court has also observed that though the wife is MBA graduate, the husband failed to show that whether she is working and getting income. As such, she is not permitted to escape from the liability to pay maintenance, and accordingly granted the maintenance. Next para. Learned counsel appearing for the wife submits that the husband has filed the income tax returns wherein he has declared his income his profit deemed under section 44 AD at 8% of rupees 57 lakhs 03 57 lakhs 3,000, or what is it, 3 lakhs? What is it?
3,000. 57 lakh 3,000.
57 lakhs 3,000. And he has paid.
That is the total receipt, my lord. That is not the profit. That is the total receipt or total turnover in my account. That's a business account, GST.
No, I'm just reading from what it is here.
Please.
Profit deemed under section 44 AD at 8% of rupees 57 lakhs 3,000. Profit declared under section 44 AD at 14.26%. And he paid the tax. And for the 3 years, the tax returns shows the income of the transactions in the similar nature. Learned counsel for the petitioner submits that, or petitioner wife submits that. In this, to show the profit, he had only shown the Axis Bank. He has only referred to the transactions of Axis Bank, and he has failed to disclose before the income tax authorities about his income from the transactions that are taken place through the Canara Bank account. It is submitted that even before the income tax department, the husband had suppressed his true income. When he has taken a when he has taken when they have taken a specific stand, when wife had taken a specific stand that the husband owns immovable properties and he is deriving lot of rents from that. In his objections, there is no, he has not filed any, he has not denied the same. which shows that the said fact is the said fact is, it's been accepted and there is no denial. He submits that the trial court, when this contention is raised by the wife, had given a finding that the wife had failed to produce the relevant documents. When the contention of the wife is not denied, their objection is not adverted, their statement is not adverted to by filing an objection. Court should have drawn an adverse inference, and court should have taken the statement of the wife. It is submitted that right from the day they are separated, he is not paying any amount for the maintenance of the wife and the child. When his income is running into lakhs of rupees, he has failed to maintain the wife and the child. He has relied on the judgment of the apex court in case of Kiran Tomar and others versus state of Uttar Pradesh and another, reported in 2022 Live Law SC 904. And relying on the said judgment, Land Council submits that the income tax returns do not necessarily furnish an accurate guide of the real income, particularly when parties are engaged in a matrimonial conflict. There is a tendency to underestimate the income. Hence, it's for the family court to determine on a holistic assessment of the evidence what would be the real income of the parties, so as to enable the applicant to live in a condition commensurate with the status to which they were accustomed during the time when they were staying together. He submits that the properties that are shown, the photographs that are filed, and the income from both the Canada Bank and Axis Bank clearly shows that the petitioner is having a good business, and only for the purpose of paying the he is evading payment of maintenance to the wife, and with the amount of 10,000 that is granted, the wife cannot sustain, wife and the child cannot sustain, and all these factors were not taken into consideration by the trial court. Next one. Land Council appearing for the respondent, the husband submits that till 2022, or till 2021, till the wife had filed the domestic violence case, he has been paying 3,500 as maintenance, and also he was paying the house rent. After without any basis, when the domestic violence case is filed, from there on, he is not paying any amount. It is submitted that he is in fact paying the school fees of the boy right from 2019. Land Council appearing for the petitioner wife had denied the same, saying that only a part of the amounts are paid, but the full school fees is not paid. It is submitted on behalf of the husband that if the wife is not in a position to take care of the husband is ready to take care of the responsibility of the child. It is further submitted that when the case was coming up for the cross-examination, right from 2022, on one pretext or the other, the wife is not cooperating with the trial. And in this regard, he has filed a writ petition before this court, and this court had given a direction to the trial court to expeditiously dispose of the MC. It is submitted that submitted that he is ready to pay the entire school fees of the boy, the child, and 10,000 to the wife and 5,000 maintenance to the son. And there shall be a direction to the wife to proceed with the matter expeditiously.
And also with regard to the bank account money. What he's claiming is the Canara Bank account it is pertaining to the business, that is the GST account, which is also linked to the PAN card. And so far as Axis Bank is concerned, even that is a savings account card, signing account, which is also linked to the PAN card. When both are linked, my lord,
It is submitted that the contention of the counsel, the petitioner, that he has not disclosed Canara Bank account is not true, as all the bank accounts are linked, that all those accounts reflect in his income tax, the statement that is filed by him. Next, having heard the learned counsels on either side, there is a material on record. The wife had taken a specific stand that husband is owning immovable properties and he's also is deriving his income is and runs into lakhs of rupees. The husband had filed his Canara Bank and Axis Bank accounts, wherein it shows that there are huge transactions as per the said account. When the wife had taken a specific stand with regard to the properties that are owned by the husband, when he had an opportunity to file his objection for the reasons best known to them, it was never adverted to. They have not stated anything in their objections. It is submitted with the learned counsel for the respondent that it is due to oversight. That aspect cannot be considered by the court when they have specifically adverted to each and every paragraph in filing their objections. It cannot be said that it is due to oversight. They have not denied the same. The bank accounts, the properties that are filed shows that the husband is having a sufficient income to maintain sufficient income, and in spite of having income, the husband is not providing the maintenance to the wife and children, befitting his income and status. When the wife is not working and and granting a maintenance of an amount of rupees 10,000, and how both the wife and the child will be able to live with the 10,000. This aspect was not at all considered by the trial court. Looking at the material that is placed before this court, the constituted opinion of the court, the wife, the husband is having enough income to take care of the needs of the wife and child, which is obligated to do. Accordingly, this court is passing the following order. Number one, the writ petition is allowed by enhancing the maintenance from rupees 10,000 to 40,000.
But my statement also may be considered, my income tax declaration also may be considered, my lord. If there is anything wrong with my income tax declaration, my lord, they are at liberty to
Now you're
initiate any
saying,
action. my
He has
lord.
not denied the 3 lakhs
then-
income, what I have
now
stated.
you're saying that 15,000 you will pay,
Lord,
15,000 you pay, you will pay 9,500 towards the rent. How much it would be?
Lord, let the matter get over, my lord.
No, don't pay the rent. Now you don't have to pay the rent. You don't have to pay the rent. That also includes in it.
Lord, even otherwise 40,000 is very over and above my reach, my lord.
The-
And so far as the rental agreement, the rents that are concerned, my lord,
30
it is only
the,
family, my lord, it is not coming to
enhanced
me.
from 10,000 to 30,000. Number two, the husband shall pay the educational expenses of the child. If if the wife had paid any educational expenses from the date of petition till now, those, she has to file the statement before the trial court, and basing on that, the said amounts have to be reimbursed by the husband to the wife. The arrears shall be paid within a period of 4 weeks from the date of receipt of the copy of the order. Once the amounts are cleared, within a period of 4 months from there on, the whole, within a period of 6 months from there on, the.
Already a direction is there from
Then-
this court.
Huh?
Direction is
No,
already there.
No, if every time whenever the court says about
No,
disposal.
he is only
No, please
prejudicing
listen to
the mind of this court.
If you are repeatedly.
No, I'm not
saying
repeating. He has
submission-
not produced the order sheet. Why it has been urgent?
Yes.
He just wanted to
The-
prejudice the case of.
But
this
you
court.
cannot, but you.
No, I'm
you
not
can't,
urgenting. I have done the cross examination. I have done the cross examination.
Within 4 weeks.
No, I have not
within-
sought.
Within 4 weeks, within 4 weeks, the amount should be paid, the arrears should be paid. Once the arrears are paid, from there on, in the next 5 months, the MC itself shall be disposed
6 months,
of.
ma'am.
Yeah, it is, though earlier order is passed, in the light of the light of this changed circumstances, it should be.
But the order was passed in the month of
disposed
April.
It
This
should be
Ap- this
disposed
April.
of, as stated, as observed above, yes. Yes.
Arrears not from the date of the order,
From the day, which order?
order of maintenance,
Not from the order, from the date of application.
from the date of application, when submission is that, my lord.
That is what is the court ordered. You didn't file any application.
Lord,
Date
they
of
have
the
been
application.
unnecessarily delaying, my lord, and because of, if my lordship sees the order.
The
sheet, my
Supreme
lord, I
Court
have-
says date
I
from the
have
date of
proposed
the
my arguments
application.
on the application.
You have to
Immediately
let the other side to talk.
My lord, if my lord peruse the order sheet, my lord, I
Well,
have
for
addressed
each
my
and-
arguments on the applications immediately after me filing my statement of objections, my
So
lord.
please
It's not-
understand, any maintenance that is granted is from the date of application is what? Maintenance petition.
Please, my lord.
That's what,
I agree, my lord, but the delay is caused by them, my lords. Unnecessarily, I have been made to pay the arrears, my lord.
yes.
Please, that one submission. Also needs to be-
Cell number,
Yes, next one.
The date of the application.
data revision, sir.
My lord.
Take that.
The counsel on record before the trial court is Vishwanath, MB
Well,
Vishwanath.
as per the orders passed by this court, the counsel for the petitioner had served the copy on the counsel appearing before the trial court. Registry is directed to print the name of MB Vishwanath in. Yes, next.
My lord, a date may be fixed. Date may be fixed, my lord.
It come on Tuesday. Yes, next.
Grateful.
Cell number 5, SG Bhagwan. SG Bhagwan for petitioner,
Yes.
Gurraja.
After that, there is no scope for any mediation or any settlement.
After serving a copy on the other side of the affidavit filed by my party as to what transpired from day one up to date, I've stated, let him have.
I'll receive it.
Take that.
Don't.
It's an affidavit.
Affidavit.
The affidavit is filed by the wife.
Just submit.
The petitioner, the respondent has served a copy on the respondent. Pose this matter after 2 weeks. Yes, next.
Lord, one submission.
Yes.
Lord, this is arising out of a miscellaneous petition, which was dismissed for non-prosecution. All this is on merits.
No, what will happen is, what will happen to your
This
amount?
filed in the year 2005.
But you should have, it's ultimately for you, all this exercise. If you want it just like that, then what will happen?
Then some kind of settlement I'll pursue it.
That's what, look at it, what he's giving.
Cell number 6.
It is not for, if it is dismissing it like that, then it's fine. It is about the arrears of maintenance and all which you will get.
Please.
Yes,
Cell number 6,
What's
Abhinay Vaiti.
filing an application to bring the.
file it in the section, you should have done it 2016, you don't appear before the court.
Apologies, my lords.
Yes, tomorrow,
Copy.
serve a copy on him, pose this matter tomorrow. Registry is directed to put up the LR petition. Yes, next.
Number 7. R Badrinath.
I appear to the appellant.
Yes,
Kindly
Harish.
pass over the matter.
Yes, next.
Cell number 8. Zulfikar.
No representation for the, matter is settled. File a memo, take that.
Compromise.
He's ready to pay 10 lakhs amount DD money.
Where are the parties? What are the clauses?
Maintenance petition for one straight.
The petitioner has agreed to pay sum of rupees 10 lakhs by way of demand draft bearing number so and so. Full and final settlement. Any further maintenance? Towards full and so and so.
Immovable properties.
The petitioner further agrees to allot first respondent share in the ancestral immovable properties acquired by him under registered partition, has agreed to execute partition deed. No, after doing it, you could have find it. After executing that party, the deed also.
That this is related to only maintenance, but the partition suit is also pending for the concerned court, Hindu, where we have to.
Oh, there it
Yes,
is.
within 1 month, they are agreed to execute
This
the
is the
partition.
only son of the petition.
Where we have to report further.
On his right title and this was the remain.
The partition deed, partition suit is also dispersed. Parent.
Where is the lady?
Into the restrooms.
MC is also pending.
MC is disposed, divorce is granted. Divorce was granted as against to MFA was filed.
Hmm. Let her come, we'll call the next case. Let her come. Yes.
Cell number 9,
Yes.
cell number 9, Vadraraj ML. Petitioner Bhushani Kumar.
Yes. Yes.
That's two things I wanted to bring to the notice of the court. First one is in the family court, matter is sent for mediation today. But whatever
It
be
is
the outcome
submitted
of
that
that
the-
mediation. that
It is,
this
the matter is sent for mediation for the trial, from the trial court. Pose this matter after 2 weeks.
Very
2 weeks, give a date.
interim
Yes,
order
next.
to be extended.
Interim order earlier granted is extended. Yes, next 10,
Please present,
present,
please.
earlier matter.
Cell number 8,
You have received the DD?
Please, now I am receiving.
no.
You have gone through all this. The compromise, this joint memo.
It is also present.
He's a son.
He is a son. Minor.
The RP, the present revision petition is on it.
The two applications are, it was dismissed for default earlier, that which I have no.
That will, the present RPFC is filed. Agreed with the orders passed and criminal miscellaneous number 90 of 2011 dated 15th September 2017. Whereby the court, the trial court had granted
10,000.
maintenance of an amount of rupees 10,000 to the son
Son,
till he attains majority, and the claim of the claim of the wife is rejected. And also, the husband is directed to pay a sum of rupees 10,000 towards litigation expenses. Aggrieved thereby seeking enhancement of the maintenance, the present revision is filed. The matter came up today. Both the parties and the councils are present, and a joint memo is filed before this court. The memo filed by the parties reads thus, the entire joint memo extracted.
compromise petition.
The compromise petition is filed.
This petition was challenged by the husband, not for the enhancement of the wife. This was challenged by his husband. To reduce the quantum of maintenance, that was.
That is, looking at the name, I thought it is
That
the revision is filed by the husband questioning the quantum of maintenance. And they have filed a compromise memo before this court. Which reads as thus. The parties are present and the wife submits that she has received a DD for an amount of rupees 10,000. And with regard to the partition suit, they will file an appropriate petition before the court. That is voice number 14 of 2020.
Before reporting, they are supposed to execute the partition deed within one from today.
Any of that is extracted in
That is it.
in the light of the compromise entered into between the parties and recording the same. The writ petition is, the RPFC is disposed of. Then in this, this compromise memo should be part, annexed to this order copy. Then IA number, where is that? It's a separate order, not, it's a docket order.
Only section 5, only section 150.
IA number 1 of 24 is filed to recall the order dated 13/2/2023. And IA number 2 of 24 is filed to condone the delay of
4 days.
498 days in filing the application to recall the order dated 13/2/2023. Considering the reasons stated in the accompanying affidavit, the delay of so and so is condoned and the RPFC is restored to file. And the order dated so and so is recalled.
Please.
Yeah. Next.
Number 10. Till number 10.
The petitioner,
Then petitioner in the 10.1 matter and responding.
Yes.
on the last date of hearing,
Yes. What is the maintenance granted by the trial court?
the maintenance granted now is 25,000 rupees to the child
Hmm.
and 35,000 rupees as expenses,
Litigation expenses.
litigation expenses.
Hmm.
My lord, when the matter was admitted,
Yes,
I pointed out to my lord
yes.
that the learned judge has observed at para 16, internal page 28,
Yes.
from the parties separated in 2017, please. In 2017, the minor child is taken by the mother to her parental home.
Yes. Give
From-
the other file. That order is in that.
Yes, ma'am.
Give the other file. Yes.
The learned judge categorically observes that the respondent mother had a total transaction of about 78,32,000 for one particular year, 2014 to 18. She closes up all those accounts.
Hmm.
And when the statement of assets and liabilities is filed, kindly come to Annexure G, my lord.
No, before that, we'll just see the order.
Please, my lord. In fact,
Let's see from para number 13.
please, my lord. I'll read from para 13 onwards, please.
Yes.
On the other hand, the petitioner has contended that by borrowing crores of rupees, he has been running his business and purchased immovable property, and he has been paying in total more than a sum of rupees 4 lakhs as EMI to his creditors. By running her own business, the respondent is earning lakhs of rupees per month, being the legatees under the will executed by her deceased father. The respondent, her mother, became joint owners of 25 acres of coffee, pepper, areca estate, and a palatial house built on half an acre of land. She holds multiple accounts in the banks and fixed deposit. She is leading a luxury life, and she does not require any maintenance from him, and she is capable of leading her own life. Parties to the petition have filed their respective affidavits in lieu of declaration of their assistant liabilities as per the guidelines issued by the Honorable Apex Court in the case of Rajneesh versus Neha. On 8/4/2024, the petitioner filed applications under sections 195 and 340 of the CRP to register a complaint in the jurisdictional magistrate for offences punishable under so-and-so, stating that she has made false statement in a declaration of assets and liabilities. In spite of giving sufficient opportunity to the respondent, she has not filed a statement of objections to this application till today. On 17/7/2019, the petitioner filed IA number 9 directing the respondent to produce a bank statement of HDFC Bank Virajpet from 2017. On 21/10/2019, the petitioner filed IA number 10 directing the respondent to produce an income tax returns for the assessment year 2019-2020 and issue summons to HDFC Bank Virajpet branch to produce a bank statement for the period 4/4/2018 till 26/8/2019 and particulars of fixed deposits. As per the order dated so-and-so, this court was pleased to reject the aforesaid IAs. Aggrieved by the said order, the petitioner filed writ petition and so-and-so on the file of the Honorable High Court at Bangalore. As per the order dated so-and-so, Honorable was pleased to dispose of the said writ petition directing the respondent to produce their income tax returns and bank statements 2 years prior to so-and-so. The Honorable High Court has also directed petitioner that he shall cooperate with this court in deciding the application. As per the income tax returns filed, as per the income tax returns verification forms produced in this case for the assessment year so-and-so, so-and-so, the gross total income of the respondent was 4,18,000, 4 lakhs, etc. The respondent has produced a statement of account maintained in the HDFC Bank by Virajpet on 12/6/2018 and 26/8/2000, a sum of rupees 23,09,410 and 20 lakhs 148, etc. were in the account, and she withdrew the entire said amount. Why I am pointing out this, my lord? It's only after I approached this court and this court directed the bank to produce the statement, she produces this. So all through the proceedings before the family court, she could not produce any details. I was constrained to come to my lord, and then after this court ordered me and directed the HDFC Bank to produce the statement, it is only thereafter she produces. This indicates the conduct of the respondent.
What is your income?
My lord, my income, unfortunately, my business, I was in the hoarding business. In the entire Bangalore city, the hoarding business is now under a standstill, and from 2016 onward, there is no hoarding business. My assets, all my properties are attached by the State Bank under SURFACE proceedings. I have declared everything in my statement of assets and liabilities. I have no income, and nor do I have the benefit of visitation rights to my child. My lord, if at least that is given, I have no objection in looking after my child. I'll beg, borrow, or steal, look after her. Neither am I given that benefit. From 2016, not a day I have seen my child.
No JNWC petition.
My lord, I obtained an order before the Commissioner for Minorities thing. That was stayed by this court. My Guardian and Wards Application Act is still pending. By one reason or other, one application or other is being filed from 2019. It has not yet reached the stage of hearing also. From 2019, it is pending.
You didn't seek for any visitation.
I've sought for it, is being stalled. Matter is not proceeded at all. That is the nature in which the respondent is conducting herself before the court. Very sad, man.
We'll ask. Yes.
Yes,
What about
After hearing her, my lord granted me the interim order.
What about your statement of assets and liabilities?
My lord,
Why did you withdraw? Why did you withdraw 24 lakhs just before filing of this MC petition?
My lords, regarding that particular account regarding Virajpet HDFC bank account, that is a joint account along with her mother, which has been opened in middle of that particular year along with her mother. But because of the particular reason that her father has expired, and to give effect to that transaction, because they were doing coffee business and all, and so her mother and father were taking care of all those things, and she was getting some income, whatever money transferred from them, that is the only source of income she was having. She was into the garment business since from the year 2009 to, my lord, 2017, until she has been thrown out of the matrimonial life. First of all, my lord, both the parties belongs to one family. They know each other, both the families together, and they got married in the year 2013, my lords. The child born in the year 2014, my lords. Thereafter, on 3/4/2017, she has been thrown out of the matrimonial form. She has been sent to her parents' house in Coorg, my lords. So on
The court records that you have not even filed your objections.
Pardon, my lords?
The court records that you have not even filed your objections.
This aspect was neither there in the application, my lords. It is subsequently brought before the court, even after arguments addressed by both the parties on the maintenance application, my lords. So this application has been filed in the year 2018, and it has.
Please come to
Yes, ma'am.
page number 27,
Please, my lord.
internal page number 8 of the order, para 14.
Yes, my lord. Parties to the
She has
petition
made a
filed-
false statement in a declaration of assets and liabilities.
No, no, my
In
lord.
spite of giving sufficient opportunities to the respondent, she had not filed her objections to this application till today.
That is separate application, my lord.
No,
Not
no, no.
that- She has filed the objection, and that proceedings are going on simultaneously along in the MC petition, my lords. That petition is going on, she is taking all the defense by her and contesting the matter, my lord. In this maintenance application.
Now, whatever the bank accounts and all show that there are any children?
Yes,
out of-
my lord, there is a daughter who is.
There
born
only
in
one
the year
Daughter.
That's all.
What is her age?
Age of 10 years, my lords.
Hmm.
So, my lord, sir, this.
From how long you're both of you are separated?
2017, please.
20?
Marriage
17.
is 2013, and she has been thrown out by 2017.
You're talking about your business and losses from when?
My lord, my business losses has been from 2016 onwards.
No, whatever it is, as far as the child is
Well,
concerned.
child, I'm prepared. Even now I'm saying, my lord, I made that statement to my lords. My lord, give me a visitation right. I haven't even had joy of looking at my child for one day.
Before like that, my lord, so
No,
they have
no.
taken an order from CWC for overnight custody and all, which we have challenged about the order grant.
No, let's forget about that. Now, now how much you will pay for the maintenance of the daughter?
My lord, whatever my lord orders, I'll pay. I have no qualms about it.
No, this educational expenses, how much are the educational expenses?
My lords, since from the year 2017, not even a single penny, except
That's
one.
what I'm asking you, what are the educational expenses of the child?
Para 15 of my petition, my lords.
Then the court, what is that?
To the tune of 6,50,000 from class KG to class 5, without the contribution from the respondent, except an amount
Well,
of rupees 20,000 euros.
As the father, don't I have a right to know to which school, where she's studying, what she's studying? What?
Welfare of the child.
Please kindly don't talk across.
No, he'll pay the fees, he will inquire about it. Then now show him.
Let him, we don't have any
No,
objection. He
you-
never wanted to, even your.
No,
No,
please tell the,
my lord,
1 minute,
please,
No, what is, according to you, your lead, as of now, about the RES you forget, what are the amounts? What are the, medical, educational expenses?
My lord, so for this year, she has made a payment of school fee of 1,70,000, my lords, by.
That is per
borrowing
annum.
from- Yes, my lord.
Per annum, 1,70,000.
Additional expense, sir.
No, she's in which standard, you said?
With her borrowing from her mother, relatives and all, my lord.
What, in which class she is?
She is now in 5th class.
5th class.
Yes, my lord.
And what is that calculation just now you're saying?
6,50,000 from KG class 2 till class 5, in which year she studied.
Class KG to class 5.
Oh.
Hmm. Now she is in 6th.
Fifth, my lord.
But you already 1,70,000, so that should be, that should.
That is not
that-
included, my lord.
That's not included.
Not included.
So 6,52,000 you have paid
6 lakh
towards her
of
education. That is, are you referring to the only school fees or any other maintenance?
School fees, my lord.
Where is she studying?
He's studying, my lord. And Virajpet only, my lord. Details I have to verify.
Now the father says he'll take care of her educational expenses.
Yes, ma'am.
Then why are you not, why you are not permitting him to visit the daughter?
We never objected for her visiting and all, my lord. He never.
Where
even your
the
lordship-
father stays, where the.
I stay in Bangalore, please.
She's in Coorg, my lord.
My lord, the Bangalore house was the matrimonial home. My lord, she went away voluntarily. She took the child and she went to her parental place in Virajpet. From that day, she's been there. All my applications to seek for visitation rights or for guardianship has been thwarted till date. My lord, without having, as a father, without having the benefit of looking at my child, they only want me to pay money for her school and education. I haven't even had a say into knowing which school she is admitted, where she is admitted, what is the nature of education she is being imparted.
When was she taken to Coorg?
In 2017, when she.
2017.
She has been thrown. Immediately within 3 days, she received summons from the MC case which has been filed by the husband while they were living together at the matrimonial home, my lords.
My lord, I have been.
So please take instructions from your client with regard to this, the school expenses.
I'll take instructions. My lord. All I'm saying is.
Also, no. Once
My lord,
you
all
take
I'm saying is, my
instructions-
lord, it should be a give and
That's
take.
why. First you take instructions from
I'll
your
take
client,
it.
then first you give her, then we'll think about take.
And also
My lord,
by-
I'll give, my lord. I'm surely, I know the mind of the court. As a father, I know but I should equally be.
It will be done.
It should be.
Ask him how much, now what is that he's going to do? Is he the client?
He's
Ask him.
here, yes, ma'am.
Ask him.
He's bearing 50% of it.
Sir, she's not working.
Hmm?
She's not, mother is not working, not having any income.
Okay, you give the child to me, I'll take care of 100%.
Cannot be the stand, my
That
lord.
can't be
Please-
done.
No,
Can't be.
so you cannot blow hot and cold. You be fair, I'll be fair. As simple as that.
No, let's not complicate things, sir. Anyhow, he never had the visitation. He never saw the child.
We have not-
Now, we'll ask him. Till now, whatever, like you have spent about 6,52,000.
Only educational expenses.
what?
Para 16
No,
comes.
that
to
we will, that's the
extracurricular
next step. So 6,52,000, half of it would be.
My lord, I have one small objection. When I have not even had the child till that, from today onwards, I'll pay, my lord. My lord, it's unfair, my lord. Please, my lord, kindly look at it this way.
It is
My
not
lord,
that. If you
my
have
lord,
not seen the child,
my lord,
the child is still growing.
my lord, that's why I said, my lord, you give me the child, I look after the child. I don't want a pie from you. I don't want a single pie from you.
Please ask your client, will he pay 3.25, 50% of that and continues to pay 50%?
My lord, from today, I will pay 50% from today. Let her give us what is the statement. Let her give her the school receipts, etc. I'll pay from today onwards. My lord, past.
She can't study from 5th class. She has to study from KG.
My lord, she has studied. That shows, my lord, they could afford to put her in such a big school. That shows that whatever statement that she's making that she doesn't have any source of income is false. They have a coffee estate about 25 acres. They have a huge house. My lord, kindly see the narration of events and the manner in which she has conducted herself before the court.
No, how is he going to exercise his visitation? That you tell first.
Yeah.
The child is at Coorg, my lord, so let him come to her home and let him visit the child for few hours, not any objection from my client also regarding to that aspect also, but only because they didn't come forward that this is not happen. Now, even before the hearing of this matter on the first date of hearing, your lordship has come up with a specific question regarding the custody. They just skip to the other aspects of the matter, your lordship. So they never came forward, and now GNWC petition is also pending, their application also pending there. So during Coorg, he has to come to Coorg. Every occasion, she has to bring the child to Bangalore.
No, that is not possible. How can the child be brought to Bangalore?
Yes.
Why she can't go? He can't go to Coorg.
My lord, I can go to Coorg. Weekends, I'll have her with me. I'll send her back on Sunday evening. I'll bring her on Friday evening.
Now,
No,
straight away,
so-
1 minute, straight away, having overnight custody, that will not arise now. Now, for initially, you have to take it slow, first 2 hours, 3 hours, then we'll think about that. Then we'll also come up with an application, we'll direct the court to immediately consider this visitation until such time this will go on.
That can also
So,
be done.
first of all, let your client on this weekend, let him go to Coorg and visit the child for 3 hours.
Please, ma'am.
You can, in Coorg, you
Let
can,
it be initially for 1 hour, 2 hours, my lords.
2 hours,
Because.
2 hours, okay.
Since from the age
2
of
hours,
3
2
years,
hours,
she have not.
2
met
hours.
him. Yes.
2 hours, let him have on this Saturday and Sunday. And in the meantime, let him pay this year's full fees.
This year's school.
Full fees first. 1 lakh, what is that?
Like 70,000, my lords.
Huh?
1,70,000.
17 or 70?
70, my lords.
Hmm. This year's fees, let him pay.
That'll be 85,000 I have to pay.
Huh?
85.
No, this year's full fees, let him pay. Anyway, we're not on the arrears, sir. Let this, for this year's full fees, let him pay.
Please, ma'am.
The,
No, I have one more. They have filed a rejoinder to my affidavit. And they say that she does not have any business called Omega Creations. I will file it with the rejoinder, I'm just passing
no,
on.
file an affidavit.
file a-
And
I'll
serve her
file a
also.
rejoinder.
Agreed by the maintenance granted by the trial court, both the wife and husband or before this court. This court on the last occasion, earlier occasion had granted stay of all further proceedings in a writ petition filed by the husband. Today, when the matter came up, it is submitted that, in fact, the father is interested to take care of the welfare of the minor right from 1917. He never had an opportunity to meet the child. The learned counsel appearing for the respondent submits that the mother had no objection if the father meets the child. And as it is, he's meeting her after a long time, it should be now it should be restricted to 2 hours, and the father can come to Coorg and meet the child full stop. It's difficult for the mother. She cannot get the child on every date of visitation to Bangalore. Next para. Though these proceedings are arising out of the maintenance case, but still considering the kind of dispute between the parties and the fact that the husband has not visited the child. Further, the GNWC petition that is filed in the year 2019, so far, no orders are passed for visitation. As an interregnum arrangement, this court is passing the following order. 1, the husband shall pay an amount of rupees 1,70,000, which you have already paid.
Yes, Your Honor.
1,70,000 to the wife by 12th of August. The father can exercise the visitation.
A little more time, please. Well, it will be too short, my lord.
He can't? You asked him?
He wants a little more time.
By
Say by 22nd, I'll pay.
by 22nd August. And in the meantime, on 10th, 11th,
10th and 11th.
10th, 11th, and on 17th and 18th, the father can exercise, father can exercise the visitation. As a child is in Coorg, on those days, evening, 4 to 6.
4 to 6.
Because
between-
no untoward incident should be happening.
They're definitely.
Because of the holidays, if any
4
problems
to
has
6,
been already
please wait.
planned.
All that will be taken care of. Between 4 and 6, the father can visit the child. Where do you stay there?
House only, Coorg only, my lords, her house only.
Visit the child in the mother's place between 4 and 6. The mother shall cooperate with the same. And also, father shall not, both the mother and father shall
Could he-
not create any
Could it
kind
be
of
permitted
inconvenience.
to take child out for 2 hours and bring her back?
Oh, that will happen next time. She
Very good.
has to come with you.
I understand.
What did you write? Shall not create any kind of uncomfortableness to the daughter and both the wife and
Both the parents shall
and
cooperate.
both the wife and husband shall maintain composure. Pose this matter on 23rd.
23rd.
By that time, by the time the amount should have been paid to the wife.
Shall I pay it or shall I deposit here, man?
No, you can ask
I'll give it.
give the bank account.
I'll give it to the council.
The counsel for the respondent, the counsel for the wife shall provide the details of the bank account to the counsel appearing for the counsel for the husband. Yes.
This dates what has been fixed, my lords, I'm not aware whether there has been any planned programs for this child.
Find out and come.
Will inform the council.
No.
My lord, she has to adhere to it. Whatever it is, you have to cancel and adhere to it. You can't say that you have any pre.
You ask her and come back. No, if it is not, then it will be adjusted, but he will have.
Whatever it is, my lord, that cannot be so, my lord. Whatever it is.
How can it be if they have some prior arrangement?
My lord,
This is not even the scope of the petition.
I know that, my lord.
No. You
My lord.
can't demand.
My lord,
Please find out
my
and tell the court in the afternoon at 1:30. You please call her and find out. Yes, and only that adjustment, but he'll have it. What are the timings and all, we'll adjust. Yes.
my lord, I may be permitted to file a rejoinder to their affidavit.
In item 10, Mr. P.V. Raju is directed to take notice on behalf of the respondent.
Permitted to file a rejoinder to their affidavit.
The wife had filed her, what is that?
Affidavit, she has filed an affidavit.
Filed an affidavit and the husband is permitted to file his rejoinder to the.
Please, my lord.
Yes. Number 11. Shita Sharma, for petitioner, 11.
My lord, I'm challenging the interim order that has been passed by the Mandya Senior Civil Judge granting an interim maintenance of 15,000. My lord, I'm appearing for the husband, my lord, who had filed a restitution of conjugal rights. The marriage was solemnized on 21.
What is the income?
My lord, I'm actually a freelance lecturer, my lord. I have completed my master's in law, but I'm a freelance lecturer. But subsequent to her leaving me, that is just prior COVID and all the subsequent events that have happened, my lord, I have lost my job. I am actually not working right now. I am also under depression. I am taking medical attention also.
Where from you're saying all this? What is the material?
My lord, these are my contentions which have been taken.
No, not contentions alone. What is the evidence?
My lord, I have
Pay
only
7,500. How much you said? 15,000. Pay 7,500. When is the date of petition? That application for maintenance?
My lord, the date of application is 29/23. But my lord, my grievance over here is not that, my lord. My grievance over here is, though I have appointed an advocate to represent me in Mandya, my lord, from the day of the notice being served on the respondent, I have not been represented even once. My lord, I have not been able to contest.
Whose problem is that?
My lord, I have not been able to contest the matter, my lord.
I'm saying whose problem is that?
My lord, that's why I've come before this court to even grant me that opportunity. If this matter is stayed and I am permitted to contest at least that IA, my lord.
What did you do if your advocate is not appearing and not contesting? Just by coming before this court and telling that my advocate is not appearing, that's not the case for granting stay. Now, if you want stay, you have to pay the money. Otherwise, take notice, we'll see.
My lord, if a reasonable amount, my lord, maybe
7,500.
7,500, my lord, I will pay. My lord, if I can deposit in the registry, my lord, whatever the directions are, I will deposit.
Half of the amount also. Half of the arrears at 7,500.
Okay, my lord, please, my lord.
So when the date of petition is 29/2023.
The date of the IA.
Not the order.
The date of the IA is 29/23.
Where do you get that?
It's at page number 62, annexure E.
62? 5/4/2023. 61 is 5/4/2023.
62, my lord.
62.
62. 62, Annexure E.
29/2023. It comes to 82,500. 82,500.
Please, my lord. 82,
6 weeks time for 82,500.
half of the amount, my lord.
Half of is 82,500.
My lord,
At 7,500, it is 82,500 because it is 10 months till now.
please, my lord, I'll deposit before the registry, my lord.
Yes, the agreed with the orders passed by the trial court, where with the maintenance of an amount of rupees 15,000 is granted. The husband is before this court, and counsel for the husband submits that the husband is not employed and is not employed and is also suffering with health issues. The advocate whom they have engaged before the trial court has not conducted the matter. In that, in view of the same, they could not bring all these things to the notice of the court. It is submitted that you cannot pay an amount of rupees 15,000 as maintenance. Next, considering the submission of the counsels on either side, considering the submission of the then counsel for the husband, there shall be stay of all further proceedings pursuant to the so and so. On the condition that he shall continue to pay 7,000, he shall continue to deposit 7,500 by 5th of every succeeding month, and the arrears at 7,500 for 10 months, that is 82,500 before 82,500 within 8 weeks, 8 weeks before the registry. If either the amount of 7,500 or the 82,500 as ordered by the court, if not paid, the stay granted by the court stands vacated without further reference to the court. Next, the petitioner shall shall take hand summons to the counsel appearing for the respondent before the trial court and shall file a memo to that effect. The memo shall be filed by 23rd of August. List this matter on 9th of September. Yes, next.
My lord, if though you have already granted stay, my lord, I'm also seeking a stay of the execution petition filed against me.
That's what stay is that.
Please.
At 12, Manjunath V. Rayappa.
Here for petitioner.
Yes.
Husband's petition, my lord.
Yes.
Husband,
This amount.
husband, my lord, 25,000 rupees awarded, my lord. There is no income proof, my lord. Petitioner working as a coolie, my lord. Petitioner paid the application.
20,000 to the wife and only wife or wife and child?
Wife and 2 children's, my lord. Wife and 2 children's, my lord. The children's 2 are.
Why that much amount is granted? What is?
Without.
What is the finding of the court?
Page number 40, and listen. 45. Para number 4, my lord. The petitioner is earning income out of real estate. Is having agricultural garden lands, growing mulberry crops such as potato, cabbage, tomato, and is earning 10 lakhs per annum by doing agriculture activities. Based on this, my lord. The RTC shows, my lord, ancestral properties, my lord. There is no this type of crops, my lord. Dry lands, my lord. Only one great.
And wife, how
My
do
lord.
they live?
Please, madam.
2 children and wife, how do they live? If you don't pay anything.
Children are studying in the RTA quota, my lord, in private school provided by the government of Karnataka. So both are BPL category, my lord, totally. Even petitioner and also respondent.
Pay 10,000.
Already paid, my lord, 50,000 rupees paid, my lord. Because during the course of next date of hearing, the trial court taken into custody, my lord. Without depositing 50,000, they won't release, my lord. 50,000.
You paid 50,000.
50,000 already deposited, my lord.
50,000 already deposited. When is the petition filed?
6 months over, my lord. 6 months, 17/2. Order dated 17/2, my lord.
When is
17/2 of
the
24.
petition for maintenance filed?
On 17/2/24, my lord.
Where do you get the date?
Page number 44, my lord. 44, my lord. Kindly see. 17 to page number 44 in annex C.
That is the date of order. I'm asking when did she file the application for maintenance?
Application filed on 12/2, my lord. Annex B, my lord. 3/2, sorry, my lord. Application filed on 3/2, Annex B, under section 24 of the Hindu Marriage Act, my lord.
Please come. The Land council for the husband is agreed with a grant of maintenance of an amount of 22,000 to the wife and 2 children. He submitted that he's a daily wage worker and he has no area and he can't pay 22,000. The court has not considered all these aspects. It is submitted that before the trial court he has already deposited an amount of rupees 50,000. Considering the submission of some.
On 8/7/24, my lord, deposited.
They shall be stay or fall for the proceedings pursuant to the order of the passed in so and so on the condition that we shall deposit 10,000 by 5th of every succeeding month. And as he has already paid 50,000, another 10,000 shall be deposited towards arrears within 2 weeks.
4 weeks, my lord.
Within
Fully,
4
my lord.
Within 4 weeks. Oh, but you say. with the
And
part of-
delivery, my lord.
with
Tomorrow
the-
is hearing that is there.
And someone's on the council for the respondent pose this matter on same like how the other dates are given. Stay is granted.
My lord, next, tomorrow is date is there, my lord. And delivery, I request hand delivery.
Yes.
Please.
Cell number 13, Amar Korea.
Lord's husband's petition, Lord's challenging the maintenance granted on 24, section 24 application. Maintenance granted, my lords, is 15,000 rupees, my lords. Lords, I'm challenging this order on 3 grounds, my lords. One is that they lived for a span of 2 months in the matrimonial house. My lords. There are no children, anything. Husband is BTech graduate. My lords. Wife is a MTech graduate. She was working before the marriage in an MNC. And then, my lords, after marriage, she quit the job. In 2021, my lords, they separated. And
No, let the other side come. Now, what is your salary?
my lords, my salary is 58,000 rupees per month.
Yeah, same 7,500.
My lords, may I submit this? There
Yes.
is a order of maintenance granted in DV proceedings also.
How much you're paying?
5,000 rupees every month. And
5,000
I
you're
have paid arrears also.
Pay another 5,000 here.
Yes, please.
Which is the date of application?
17/9/2021 minutes.
17/9.
2021.
21. Almost 35 months.
Yes, ma'am. Could I request it to be from the date of the order, my lords, because there is no consummation of marriage, my lord. She is highly educated than him, my lords. She was
Deposit
working.
before the court. When she is not entitled, then we'll see.
Yes, ma'am. Kindly, that direction will come.
Then the present petition is filed agreed with the order of the trial court granting 15,000 as maintenance. It is submitted that the wife is MTech graduate and the husband is BTech graduate. His income is only 58,000. It is submitted that the wife is more qualified and the husband is paying in amount of rupees
5,000 every month.
5,000 in the domestic violence case. The court, without considering all these aspects, has granted the maintenance. Considering the same, there shall be stay of all further proceedings pursuant to so and so on the condition that the husband shall pay an amount of rupees 5,000 by 5th of every succeeding month. And for at 5,000 arrears comes to 1,75,000 for 35 months. 35 months, the same shall be deposited within 4 weeks before this court. Either of it, same clauses and same dates
Lords,
for the memo and all.
Lords, one. A stay I have sought as far as this order is concerned. It's not
That's
the
fine.
entire.
It's only, that's why the court is very specific. Stay of all further proceedings pursuant to this order.
Cell number
MC
No,
order.
my submission is only execution of this order be stayed.
That is what,
Let the
uh,
proceeding.
That is, if it is, otherwise the court would say stay of further proceedings in MC.
Yes, ma'am,
But
that is
only
not-
this order.
That is not.
Yes.
Cell number 14, Venkatesh Somareddy, petitioner.
Yes.
Yes.
Husband's petition. Originally divorce proceedings filed by the wife in Mumbai, and the matter was before
Question,
the
what is the improved order?
Honorable Supreme Court transferred the proceedings to Mangalore. And before, at that time, my lord, the Honorable Supreme Court considered the mediation report, and Honorable Supreme Court itself mediated for a long time. Wife was in Canada at that time. The Honorable Supreme Court noted this in the order of transfer, that wife is employed and she is in Canada. Therefore, no question of granting any maintenance. And no question of paying any other.
Did you
amount.
get that?
That page 52, the Honorable Supreme Court's order. Page 56, my lord, may kindly see.
Yes.
In fact, a petitioner being a permanent resident of Canada was habituated of that lifestyle. Marriage was just to spoil dash dash. Then my lord, the middle portion, got a job in ICICI Bank. After reaching Mumbai, she applied for a job in ICICI Bank, etc. Then my lord, para 9, she purchased a flat, etc. Then kindly see the reasoning of the Honorable Supreme Court's order. Your lordship may kindly go to page 61.
Yes.
Para 20, considering the state of the parties and the fact it's a petition filed by the wife seeking transfer of the case filed by the husband from Mangalore to Mumbai. In our opinion, case, no case is made out for transfer of the petition from Mangalore to Mumbai. Wife is a permanent resident of Canada. She must be traveling abroad regularly. As she is evident from the observations of the mediation report dated and submitted by Justice Vijay Vasivda. The petitioner was in Canada throughout the mediation process and attended the proceedings online. There is no child born of those ones. Both the parties are well educated, engaged in their own jobs and professions. She can travel to Mangalore to attend the hearing of the case and can also seek exemption. Though at present, considering the financial condition of the parties on the basis of the material to come on record, we do not find any grounds made out for issuing direction to the respondent to pay the expense of petition for traveling to Mangalore. Still, in case she feels like seeking reimbursement, she shall be at liberty to file application. Now what? And finally, my lord, she now files an application for maintenance and for reimbursement, etc. That the Honorable Family Court holds. Her income is about 2 lakhs per month, and she is not entitled to.
Where do you get that?
That, my lord, may kindly see, my lord, page 165.
Page?
165. Para 34, my lord.
Yes.
That she has been working abroad. And about the income, page 164 with kind permission. Kindly excuse me, page 164, para 32 shows the income, etc. She has received several lakhs. It's in the account. Para 32, para 33 about the property of 2 crores. Para 34, she is working abroad and she was in ICICI Bank, etc. And after holding this, page 166, third line, last year she received more than rupees 15 to 16 lakhs on credit, as credit or deposit, etc. Then para 36, last line, there's nothing to show that she is unable to maintain. And my lord, finally, the application of maintenance was dismissed. Operative portion only I beg to now read, my lords, page 171. The prayer of the please, my lords. Page 171, please, my lords. Prayer of the IA number 6 so and so is hereby allowed in part. Prayer of the respondent wife for maintenance pendant.
8,000 is granted.
Now this problem is this, is entitled to sum of rupees 8,000 per month hearing. Now my lord, she is employed now in Mumbai. When she comes.
You are in Bangalore and you are.
No, only thing is this, my lords. Only thing is, now I will not say, I will only say, my lords. My lords will decide on this for this reason, my lords. It's not the question of 8,000. For this, she has been dragging on the proceedings on this count, my lords. Our grievance is this, my lords. Now, whenever, if he is really entitled to is one aspect. My lord.
That too, the Honorable Apex Court has has already observed that, she
If-
can do it.
If.
She can do it. So you say you can, now you
Yeah.
cannot say that she cannot.
That I won't say. I would say this is not justified in doing. May I submit only this, my lords? I will deposit the amount before this one. Could your lords may kindly decide whether she is entitled to this amount? Because let the matter go on. As far as the amount is, actually, she also doesn't want this amount. Because her income is several lakhs of rupees. Now,
Then we'll order notice instead of passing any orders in this.
and as per this, because of this amount, now what has happened is, my lords, now kindly see page 171 there afterwards, page 188, the learned special judge, family judges calculated the amount payable for the dates when she has appeared and said he has to pay for page 188, my lords.
For a sum of 8,000 from the petitioner husband on each and every date of hearing towards a traveling expense.
Yes, yes.
Attend
And
this court for defending his subject.
please,
and
ma'am.
so-
And afterwards, there is one more order passed at 188.
But court was very reasonable.
My lord, she was actually not entitled to at all this amount because her income is more.
No, then
Admitted.
where she wanted this proceedings to be transferred.
She wanted in Mumbai. Supreme Court,
Let it go to Mumbai.
Honorable Supreme
again
Court
on your-
itself said,
No,
my
no.
lords.
Now you tell that I'll not pay 8,000, let the matter go
No,
to Mumbai and I'll not, then she will not ask for anything.
Honorable Supreme Court, lengthy judgment, my lords, observed her conduct.
That's
She has
what,
separate,
you
separate
don't-
everything.
Your client can't have both.
I may only submit, my lords.
Yeah.
Now that in page 188, they say you have to deposit 24,000 and 5,000 towards the cost 29,000. This is one aspect. Last para says if you don't deposit, then the further proceedings are required to be stopped. Now, my lord, we don't want the further proceeding to be stopped. At the same time, my lord may kindly decide whether she is entitled to this amount or not. As far the deposit is concerned, I am.
Hey, no, now itself I'll decide.
I-
Without issuing notice to her.
She has also challenged the order, my lord. So
This order.
she has challenged the original order. There is a writ petition which is pending before
No,
the
that's
Supreme
what,
Court.
if that is there, both will decide.
That
Where-
your lord
what
may
is the
go.
number?
In the my lord, may I have mentioned in the writ petition, my lords, that is.
Post along with it on Monday.
May I pray one aspect, my lords. That's 84825 of 2024.
Yes.
WP number. In the meanwhile, may I only submit this, my lords? Now that I have understood my lord's words, you kindly permit me to deposit this said amount before this honorable court or the trial court, whichever my lord votes, this 29,000 amount. I will deposit because it's my duty. Understood, but I will deposit it now. And my lord will decide it because we will definitely decide the matter because we will be able to satisfy my lord that making the claim of this amount is not proper because of our conduct, etc.
So the purpose of having that petition is we'll dismiss that petition and we'll dismiss this petition also.
That I understand. That's
For
what I will make my endeavor.
On Monday. Post
Your lords
along
may
with it.
direct, may I pray my lords direct us to deposit this amount
Yes,
and
it will come on Monday, that will decide that itself on Monday. Monday, post on Monday.
Please,
Along
please,
with so in
please.
30.
Would it be,
Will complete this 14 also?
please, madam, that's WP number. Yes, we'll give the number.
It's 14.
Please, great.
Huh? This is the last one, okay. So, they say hand delivery and they prepare it and they don't take it. Every time this is what is happening. Tell the advocates, we'll continue with the list. All that, on this part heard matters, oh, this is one. We'll continue this list, then we'll take 230 and the password matters. Password matters after the list is continued, only one password.
Let's continue.
portion of that is still remains mine. I will show that. The written statement is at page 257, which is filed in the suit. And the portion of the will where they have admitted, I will just yes, para 14.
Yes.
Para 14. In 2003, Shri T.B. Nanjundaswamy passed away and left behind a last will and testament dated 10/1/2002, by way of which the plaintiff acquired T.B. Nanjundaswamy's share in survey number 156. The description of plaintiff's share in survey number 156 as mentioned in the will is as follows: 4 acre 23 guntas of coffee plantation land in survey number 156. True copy of the will is so and so. In fact, they only had the aunt only had the original copy which she produced. Then it is clear from the above paragraphs that plaintiff has deliberately misdescribed the share of survey number 156. Now, what her claim is, first defendant's claim is, I have misdescribed the property. In the property, the bungalow should not be included. The submission is the will, there is no challenge to the will. Neither has she challenged over the last 20 years, nor has she said this will is not correct. Now you say if the will is correct, then you say within that 4 acre 23 guntas where there is a bungalow or the kharab land, it is all part of 4 acre 23 guntas. That is the reason why I'm seeking the declaration suit, because an allegation is made that within that 4 acre 23 guntas, they still have a part of it. Then you should have challenged the will. Let me show, my lords. First, may I show both? I'll show both, the partition deed and the will. My lords, the partition deed is at page 52. May I refer to it, my lords? Partition deed is at page 52. And if my lords can see at page 57. It is not a case of misdescription. May I refer to one minute? My lords are reading the WS, or?
I'm looking at the order.
Ah, in fact, I wanted to point out in the order which are some of the relevant portions to review.
No.
May I
please show
take my lords through
please
the
show
order? Because before the order, the.
No, please show the plain schedule property.
I'm sorry, my lord?
Plain schedule property.
Yes, and there is plain schedule is at page 247.
Page number?
247, my lords. Yes. Schedule is coffee 247, my lords have found it.
So simply it says, schedule is survey number 156.
Coffee plantation in survey number 156/P, total measuring 4 acres, 23 guntas, including Kharab, bungalow, writers' quarters at so-and-so village, Chikmagalur, Tadma.
Please come to the partition deed.
Yes. Now, my lords, kindly see the partition deed, which is at page 52.
52.
And within 52.
52 is 252.
No. Sorry, just 52. Page 52.
Page 52 is order. Page 52 is the order. In this
I'm
bunch
sorry,
of
next
papers.
page, just the next page. Maybe there is one page difference.
Oh, partition deed, yes.
Next page. And if my lords can go to the relevant page, internal page 6 of the partition deed, in my pagination, it's 57. A scheduled property allotted to the separate share of TB Nanjundaswamy. My lords have found that. That is the grandfather. So what falls to the share of Nanjundaswamy, number 1, survey number 156, coffee acre, coffee acres 423, that is 4 acre 23 guntas, assessment.
Yes, I have seen that. So,
Yes. Now here it says, kindly just allow me one line. This land contains 3 cattle sheds.
That also I have seen.
Yes, the bungalow, sheds and the writers' quarters. Now, in the same partition deed, if my lords could see page, internal page, my pagination 62.
Yes.
I'm sorry. If my lords could see 61.
Yes.
61. B scheduled property allotted to separate share of T.N. Ravi Shankar, who is my father. And if my lords could see the next page after that, at number 8, serial number 8, half of the land out of survey number 156 acres, 1 acre 15 guntas, this land consists of residential bungalow and drying yard. So if we were to understand it, we are trying to make sense of a 1970 document. And I just want to show one more page before we just analyze it. Identical share is put at page 64. Kindly see page 64. My lords will get a better idea. That 1 out of 4, same thing is put even to the uncle. Just for a moment, my lords. Page 64, C scheduled property is the property to the share of Shri T.N. Ashok, which is the uncle, on the same page, serial number 9.
No, the how it is mentioned is different.
Half land out
of the grandfather, it says it inclusive of 3 cattle sheds and writers' quarters. That is in respect of grandfather. When it comes to the father, it is residential bungalow and drying yard in respect of the very same land.
Yes, but the actual land, if we see, the instructions I have got, how the portion is, the 4 acre 23 guntas, if I can just explain to the best, 4 acre 23 guntas is 1 plot.
Yes.
Now, within that 4 acres, the whole thing,
yes,
within that 4 acres, there is a portion in one portion inside 4 acres, which is the bungalow and the drying yard. Inside 4 acre 23 guntas. If this is 4 acre 23 guntas, inside it is the bungalow and the drying yard. Now, the partition deed, if we are to make sense of it, entire 4 acre 23 guntas On one hand, it says falls to the share of the grandfather.
No, that extent is 4 acre 23 guntas.
The whole thing, that one, the bungalow is within 4 acre 23 guntas, is part of it. If I
So
take
what
up,
has he got as that 4 acre 23 guntas excluding this, these
no,
two
no, no,
things.
may I try to make sense of what I see. In the grandfather's share, it says survey number 156, 4 acre 23 guntas, leading to estate bungalow, road leading to, that is the road, sorry. This land contains 3 cattle sheds and writers' quarters. Now, if the bungalow was excluded, I'm just making that statement to myself to better understand it. Out of 4 acre 23 guntas, if the bungalow is excluded, then I will not get 4 acre 23 guntas, because that bungalow is about the bungalow and those sheds is about 1 acre 15 guntas, which is inside it.
So now this is.
Now,
then about the other brother?
yes, both.
From that we will understand
No.
what is the intention.
Now, other brother also same identical.
Unless see that.
They are both given to share that 1 acre 15 guntas, which contains the residential bungalow and the sheds. Within
Where do you get that?
I mean, yes, where I get it is that first is to T. N. Ravi Shankar, who's my
that we have
father.
seen. Residential bungalow and drying yard.
It says half the land. Half the land of 1 acre 15 guntas, residential bungalow drying yard. The other brother, whose widow is the lady, at page 64. See schedule property to Shri T. N. Ashok at point number 9. Same identical what is given to my father. Half the land out of 1 acre 15 guntas consists of residential
So
bungalow.
from this partition deed, it is clear that the intention of the parties is out of whatever is the land, vacant land is concerned, and this, what is this?
The house, basically.
No, that is, he referred to it as the names are given differently. Writer's quarters is part of grandfather's share, and the residential bungalow and drying yard, both the brothers will have half.
One may look at it like that. One may perhaps make sense of it like that. The only thing to remember is that bungalow and that yard, drying yard, is within 4 acre 23 guntas. Now, whatever may be the intention, let us assume that was the intention. But the entire 4 acre, there is some, I would say, there is some anomaly, because the grandfather gets 4 acre 23 guntas. It does not say I get survey number 156 excluding.
The entire extent is 4 inch. So that excluding is the only one missing.
Yes, excluding is not there.
Otherwise, if we can understand with regard to one brother, when it comes to the other brother also, it is clearly mentioned.
No, both brothers are given that. It is not a one brother.
Now let us come to the will.
Let us see the will.
Page
Now let
number?
us see the will. Will is at, the typed copy is at page 91. Page 91.
Yes.
Now the will is made by the grandfather. Kindly see page 92. 92.1. Interestingly, in the will, the son, which is T. N. Ashok, is not mentioned. Only his wife is mentioned. So point number 1, coffee estates and wetlands detailed in the schedule after my demise shall be taken over by daughter-in-law, Srimati Lata, and grandson, that is myself, T. N.
So please
Ishwar.
come to the schedule.
Schedule. No, this is now schedule A, schedule B. That is at page 93. What is given to defendant 1 and what is given to me? Schedule B, defendant, schedule A, there is nothing of 156. No portion is there. Schedule B, given to me, 156P, that is what is the plantation, 4 acre 23 guntas is given to me.
Now, here the question is, between 1970 and 2003, are there any mutation or revenue entries in favor of defendant number 1 or her husband?
Yes. No. My submission is that till the grandfather was alive, Nanjunda Swami, all the entries are only in his name of 156. All the entries are only in his name. Not only are the RTC entries in his name, I have later on produced even the gas bill, electricity bill of the bungalow, where the electricity and living was done, also only in Nanjundaswami's name. Thereafter, after the will, the mutation. When the mutation happened only after the will. Will is made in 2002, 2003, he dies. After the will, the mutation is happening. Now, one may say that the intention at the time of the partition perhaps was that both brothers will share the bungalow and the shed. Yes, one may assume that. However, by the time the will was made in 2002 and the entire...
A person cannot make a will of the properties which is not the owner.
I'm coming to that. Yes, my lords are right. Only if I have the property, I can will it to somebody. After the will was made, and when the will, not even after, at the time the will was made, the far before that, the brother, which is Ashok, and his wife Lata and family, in fact, have always been given other properties and were never there. So the intention, whatever may have been an initial intention, ultimately, by the time the will was made, the intention was that Lata will be given other properties, which she was given, and I will give this property to this brother,
What will
this
happen to
son.
a partition deed which is effected way back in 1970?
No, now I ask myself, for whatever said and done, there was a partition deed made, which I would say is not clear.
When
there
is
is
the suit filed?
Now this suit, I just want to make a submission. This suit is filed when they started after the
Year, which year?
yes,
Suit is of the year 2020.
22, because
20.
the younger brother died.
No, at
Only-
least
yes.
from 2003 to 2022.
There's been no problem.
No, you are enjoying the property. What is that to show that you
Yes.
have been in possession of the property?
Yes, I will show, my lords.
Please come to the order, and from the order you
Yes.
please point out.
Yes. Now, may I just show the order and some of the observations in the order, which according to me are not correct. The reasons start at page 38.
No, it's not about what is not right with the order.
Yes.
It is about how you are in possession of the property and why the court has not failed to.
Yes,
court failed to
yes.
appreciate it.
Yes, I'm in possession. My submission is I'm in possession of the property by virtue of the will, and I have produced documents to show my possession. I will clarify why the court has not considered.
What are the documents?
Yes. May I read out the order?
No, you can tell it because of the
Yes,
reading and all it depends.
the documents I have produced are the will, the mutation records, and the RTCs. In the
Mutation
plate.
record which is there in the name of your grandfather.
No, my lords, the mutation, yes.
Oh, yes.
And my name also. No, mutation is in my
when
name.
is in your name?
Yes, that is in the year 2011.
In the year?
2011.
The entire bungalow is in your name now.
The extent, in fact, the extent in the mutation is problematic, and to that effect, the extent I have filed an appeal.
That's pending.
Yes. But the mutation.
Which is mutated.
But in his, the mutation entry shows, my lords may see at page 241.
Yes. Yes.
241, though it is in Kannada, allow me to just translate. In the first column is the number 156. In the second
His
column,
name, Nanjundaswamy.
Nanjundaswamy, 3 acres 6 guntas, and then to whom it is now given to is T.D. Ishwar. That is the plaintiff, which is 3 acre.
That is with regard to the land. There is no dispute on that.
No, now let me just pause here. Let us assume there is no will. Let us assume I take the case of the defendant. That the partition deed says total extent is 4 acre 23 guntas. Within that 4 acre 23 guntas, the bungalow and the yard is 1 acre 15 guntas, which both brothers are both given half share within that. If so, even if I for a moment say the will is not correct, then my share would be, I mean, even if I say that I believe the plaintiff's defendant's version, my share would be still half of 1 acre 15 guntas in addition to the rest of the property. So this even 3 acre 6 guntas is neither here nor there. If I have to, if they want to keep half share of their 1 acre 15 guntas, 1 acre is 40 guntas plus 15. So about 20, 35. About 35 guntas would be not even 35,
No,
about
no, because
27.
it is about there is a
But-
proper, there is a bungalow, there is a house in it.
No, but there is a measurement of that house, my lords. The
Mhm.
house is not without any measurement. So even otherwise, 3 acre 6 guntas does not add up. If they have to retain 50% of the residential bungalow and drying yard, they would only get about 30 guntas. So I should still get more than 3 acres 6 guntas. I should get about 3 acre 20 guntas or so. Not even, I'm sorry, I think about 3.5 acres I should get. So this mutation is an arbitrary number put, 3 acres 6 guntas. There is no bearing to either document. And being aggrieved by the extent, I have filed an appeal, which also I have produced. Because this extent is wrongly put. Thereafter, my lords may see the next page, the RTC, kindly see 242.
I understood your argument.
Yes.
We'll ask.
Please.
But I wanted to point out a few more things. May I just produce few more things and then I may say. Now, my lords may kindly see, just for a moment, page 96, 2-3 other documents. Two, three documents I will show.
No, the defendant is denying the, yes, Mr. Counsel. The defendant is denying in respect of the entire, all other properties or only with regard to the house?
Only as regards the house. In fact, Your Lordship, we are disputing the scheduled property description only as regards that bit of bungalow. And I will show limited to that. If I may bring Your Lordships
No,
back to.
I just
Oh,
wanted
I
to
just
have
wanted
it.
to show, in fact, the house. Kindly see 96.
Mm.
96. This is the electricity bill of
His name there,
2018.
not just one.
Yeah, Nanjan Swami. Next page, my lords. 99 is also the
Yes,
electricity
you'll
bills.
take it that all the bills are still in his name.
Bills are in his name.
Mm.
And in fact, page 100 onwards, the gas bill is in
Yes,
my
I've
name.
seen that. Yes.
Yes.
Mm.
And then, my lords, the photos from page 118, where extensive renovation, nearly 50 lakhs worth of renovation has been carried out over the last 3-4 years by me, because I'm living there with my father and family at page 118 onwards. And in fact, photos are there and even all the bills are produced. Though, my lords, the photos and bills were not produced before the trial court. In fact, all the renovation has been done over the last 3-4 years. And the last document I want to show is, my lords, even after the suit is filed in 23, I get repeated legal notices from defendant number 1, saying that you are denying my entry, which prima facie shows they are not an entry. Yes. And saying, let us go for mediation.
Page
Yes,
number.
I will show you. My lords may see. Yes. Page 305. Page 305. This is legal notice dated 16/8/23. Which is after the suit. 16/8/23, while the suit is pending, we are getting legal notices from the defendant, and kindly see at page 309.
Yes.
Page 309, para 9. In fact, they say para 9, as a final attempt to amicably solve the dispute, we call upon you to so and so ABC mutually to appoint a professional mediator. In fact, I replied back saying the matter is for mediation there in Chikmagalur. Please come. We are always ready for mediation. They have sent us 3 notices which I have produced after the suit. In fact, subsequent notices, kindly see at page 290, 18/7/23. And here they say that you are not allowing us into the bungalow, which means they are not in the bungalow, which I will show. The notice starts at page 290 and kindly see at page 292. 292, just above para 7. The first line above para 7, our clients inform us that despite sharing joint ownership over item number 1 property, you and your family members have been obstructing our access to the residential. Sorry, Manoj, 292.
Yes.
You have been obstructing our access to the residential bungalow. And then again, they say that at the end of it, at the end of that legal notice, they say, we want an amicable partition, or we want an amicable thing. If they want an amicable resolution and they want to go for mediation, definitely we can go for mediation. There is no difficulty. But
Yes.
this shows that we have always been residing therein.
Yes. Yes.
Your Lordship may take the partition deed at page 52. I will clarify any ambiguity in the partition deed by way of the clauses in the partition deed itself. Page number 57, as learned senior had pointed out, paragraph number 1.
Yes.
Survey number 156, coffee acres, so and so. Land contains 3 cattle sheds and writers' quarters. If your Lordship may scroll down to page, may turn over to page 62, paragraph 8.
Yes.
Half of the land of survey number
What we have pointed out 8 and the next page
Please.
at last at page
Please.
number 30, bottom at 9.
At page number 56 now, your Lordship, paragraph number 7, if I may read.
50?
56. 56, paragraph number 7 at the bottom quadrant. The residential house and coffee estate, the adjacent drying yard, and the pulper house in the coffee estate have fallen to the shares of second and third parties only in equal shares. As it is not immediately convenient to divide them by metes and bounds, they shall enjoy them together and may effect division with the help of surveyor whenever it is convenient. As the first party has not been allotted with any residential house in the coffee estate, drying yard or pulper, he shall have the right to use them till he makes separate arrangement. There is the ambiguity that should be resolved, your Lordship. Further, if I may go one step further, the learned senior is painting the picture that the entire survey number 156 is only 4 acres, 23 guntas. That is not the case. If your Lordship may take the impugned order,
Yes.
paragraph number 9 at page number
Yes.
40. It is relevant to mention herein that at the pleading stage itself, parties are not disputed in respect of the will. I am also a beneficiary under the will. I have not disputed the will. So and so by its legator and even by defendants have not disputed the fact that the testator of the will so and so forth. The plaintiff has made an allegation that defendant number 1 and 2, they have got mutated the name 27 guntas in respect of the suit survey number, which is half of 1 acre 15 guntas, which is 27 guntas. That is exactly what I've gotten mutated to my name.
In which year?
2011. There has been some delay as regards the mutation. I have to, please.
27 guntas.
Please. If your Lordship may continue reading the last 5 lines, whereas defendant number 1 has contended that though partition deed dated so and so, the land comprised in survey number 156 measures 6 acres 8 guntas. If the RTCs of the survey number 156 is taken, it will very clearly demarcate that the entire survey number is 6 acres, 8 guntas. So there is enough space for them to get their 4 acres, 23 guntas, and for me to get my 27 guntas, and for respondent number 2, who is their father, to get 27 guntas. Any confusion caused is only for the benefit of the plaintiff in this matter. If now the case in summary, your lordships, is this. In 1970, there is a registered partnership deed. Properties are divided in that registered partnership deed. Both parties have admitted to the document. Subsequently, a will is executed in 2003, whereby the same property which is received by the appellant's grandfather is bequeathed to the appellant. Like your lordships has very well pointed out, the grandfather cannot bequeath property that does not belong to him. Subsequently, after 2003, they receive share of survey number 156. Thereafter, in 2022, they approach this honorable court by way of filing a plaint. And for the first time, the description of the scheduled property includes the word bungalow. So any confusion that is being caused at this stage is for the benefit of the plaintiff itself. In fact, the learned trial court, after going through all of the admitted documents and the revenue records, and it is not as though the trial court has relied on revenue records to confer title. They have relied on the partition deed of 1970 and the will which the plaintiff themselves have produced before the court. The trial court has held that there is no prima facie case, and I think one paragraph may be relevant in the impugned order. Paragraph 12 at page 44.
Yes.
Apologies, paragraph number 13 at page 20, Your Lordship, sorry. If I may read the 5th line from the top.
Yes.
This aspect to be agitated in full dress trial. When such being the question, the fact in dispute, it is highly difficult to hold that plaintiff has made prima facie case. That apart, the plaintiff has deviated from the description of the suit property compared to the undisputed documentary transaction, which by way of which they mean the partition deed and the will. The plaintiff has relied on the partition deed and subsequently the will, but in the plain schedule, they have deviated from the partition deed and the will, admittedly.
Yes.
So these two paragraphs are relevant as regards the impugned order. As regards the subsequent, there are some other averments, Your Lordship. However, it may not be relevant. I had made some submissions as regards the fact that the appellant has produced fresh documents not produced before the trial court without any application under the relevant order. They have also introduced fresh averments which were never introduced before the trial court. In fact, as on date, Your Lordship, the matter has been pending for the stage of plaintiff evidence for 12 months. They have not appeared before court once. So that conduct may be relevant in this case as well. And despite all of this, Your Lordship, they approached the Honorable High Court in my absence and they procure a status quo order. And they use that status quo order to restrain me from accessing my property. Now, I have to be fair to the court. It is true that after the demise of my husband, I moved out of the property. However, I never stopped using the residential bungalow because the residential bungalow is at the center of an estate. I cultivate coffee. I have to store the grains and I have to use the pulper yard and the drying yard. All of this is part and parcel of the property that is owned by me. However, since my relative was staying there at that point in time, I moved out after the demise of my husband. Now at this stage, they stop me from using the residential bungalow for storing the grains, and they also stop me from using the drying yard and pulper house, which is essential to me getting any income from the coffee. Which is why I had also filed an application for clarification of the status quo order that may be dealt with with the admission itself.
May I submit? My lords, first of all, my learned friend has in fact stated the correct position that she has not been in the bungalow. And I appreciate that he has said that because that is the truth. The second portion that she is coming back to use the drying yard with great respect.
That should also be appreciated.
No, but that is not correct. Where he is saying correctly, I am sincerely appreciating that he has been fair to say that because that is the true position. She the defendant number 1 and her family have never been, have for many years moved out.
Yes.
And therefore they have not been in possession. To say now after moving out that now I want to come back and use the drying yard, which if we read along with their own legal notices saying now you're obstructing. Yes, now I'm obstructing because you have moved out and you are not there. So therefore we don't want to create more rights, and therefore definitely there is no dispute that I'm obstructing.
Yes.
And now my lords may kindly see the 6 acres, 8 guntas my friend said. That is his contention. No document says I've got 6 acres, 8 guntas. It is only 4 acre, 23 guntas. My lords, I want to point out a few portions from the impugned order. Kindly see, my lords, page 43. Just few portions of the impugned order.
Yes.
Which are problematic. Para 11, the last 10 lines. Para 11, my lords have got, yes. Thus it shows that the description contemplated in the partition deed dated 25/3/1970 shall prevail over, and the said document is clearly contemplated contemplated the description of the property therein. Partition deed dated 25/3/1970 has not contemplated that the land in survey number 156P measuring 4 acre 23 guntas of so and so is comprised with any bungalow or structure except 3 cattle sheds and writers' quarters, as against the description that the plaintiff has contended that the suit is comprised with kharab, bungalow and writers' quarters, whereas partition deed relied on by the parties recited that the share fallen to T.N. Ravishankar and T.N. Ashok comprised with the residential bungalow and drying yard. Partition deed has not at all contemplated that the share fallen to T.B. Nanjundaswamy is comprised with kharab, other than to the extent of 4 acre 23 guntas land. Now, my lords, the finding that partition deed will prevail over even a will. My lords, my humble submission is, it is only a prior document. Yes, it is a prior document. But does that mean that the will is invalid? The will wherein the entire 4 acre 23 guntas has been given to me has not been challenged. There are other portions of the will. In fact, the same judgment, in fact, says that they have admitted the will. They are also not challenging the will. So to cull out a reading that the 4 acre 23 guntas is given to me, but the bungalow, though the description in the partition deed may not be there, whatever may be the intention that the bungalow should be given to both of them, but ultimately a subsequent document gives the entire 4 acre 23 guntas to me. And she is not there in the property. She is also moved out of the bungalow at the time of the will because she has got other properties in the will. And they have always been residing separately. So now, only after her husband has passed away, all this interference has started. If there was any confusion with the will or the partition deed, what prevented defendant number 1 to go to court for any declaration? Or to say that this bungalow is mine and therefore the will is to that extent incorrect? You could have said that. I have only filed it because the interference started. Now, my lords, my humble submission is that the only documents, the mutation also shows that the property is in my name.
Yes.
The extent is disputed. To the extent I have already filed an appeal which is pending. Now, my lords, thereafter when I filed this MFA, it is not correct. I would not, in fact, appreciate what my friend said that behind his back, I've gone and taken an order. We filed the MFA. At the time of admission, a status quo order is given. Then notice is issued. That's all. That is a normal course. If the court, the court is convinced, the court will give an interim order.
It is filed even if you come.
Yes.
Exactly. If he makes out a case, you will get it.
Very well. I'm only pointing to.
No, what I understood is you filed caveat and without
Yes.
notice to you, they might have.
No, not at all. We can't do
Yes.
that. There is status quo order is given. We said, kindly maintain status quo. If I am there in the place and they are outside, let it be like that. Let there not be any further change. And in fact, that is all we want to continue. And we are ready. Even if they have asked for mediation, we are ready. There is no difficulty. But let status quo not be disturbed, my lords.
Yes.
They are right now not in the property. We are in the property by virtue of the will. And that should continue. And ultimately, based on evidence or whatever is the suit, if I get the declaration, I get it. If I don't get it,
Please come. The present petition is filed, the present appeal is filed. Read with the orders passed. Is it happening? Why? What has happened? You have to? Okay.
Or even if my lords were to say that the trial court to reconsider this matter on these grounds also, I leave it to my lords.
Leave it. It's not happening. Agreed with the order. Passed in I number 1 in OS number 162 of 2022, dated 10 July 2023. The plaintiff is before this court. The plaintiff had filed a suit for declaration and for injunction. The plaint page number,
Plaint, my lords, is at page number 243.
2,
243.
filed a suit for declaration and injunction to declare that the plaintiff is absolute owner of the sue scheduled property under the bill dated 10/1/2002 and also sought a permanent injunction. The sue scheduled property is coffee plantation in survey number 156/P, total measuring 4 acres 23 guntas, including Karab and bungalow, writer quarters, situated at Togari Hangal village, Jagra Hubli, Chikmagalur Taluk. Along with the suit, he has also filed I number 1 seeking ad interim injunction. It is a case of the plaintiff that the plaintiff that the suit scheduled property, that is a coffee plantation in survey number 156P of 156P, measuring 4 acres 23 guntas, and bungalow and writer's quarters. He got this property by virtue of a will dated 10/1/2002, which was executed by his grandfather by name T.B. Nanjun Swami. He died on 26/1/2003. After the death of the grandfather, the plaintiff became the absolute owner of the property. He has been in continuous possession and enjoyment of the property. He had renovated the bungalow by investing more than 50 lakhs. According to the plaintiff, except the plaintiff, no other person has any right to the property. It is this case that in the year 2011, the first defendant, without the knowledge of the plaintiff, has filed an application before the revenue authorities for changing the kata and changed the kata of an extent of 27 guntas and an extent measured in the name of the father, her name, and an extent of 27 guntas in the name of father of the plaintiff. Now the plaintiff intend to file an appeal against the said entries made in the records. It is the further case that taking an advantage of the said revenue entries, there is the defendant who is none other than the paternal uncle's wife is interfering with his possession. And his position which made him to file the present suit. To that, the defendants have filed their written statement. In the written statement, they have stated that there was an earlier partition dated 25/3/1976, correct?
Please. 25/3/1970, 70.
25/3/1970.
Please.
25-3,
Partition B? No, it is 25/5/1970.
25-3/1970.
Sorry, 25/3/1970.
25-3/1970. As per the said partition deed, the residential bungalow and drying yard, half of it fell to the share of the plaintiff's father and the defendant's husband. It is their case that there is discrepancy in the suit schedule property, the partition deed and the will, and the will deed dated 10/1/2002. It is the case of the defendant that in the year 2011 itself, part of, as per the partition deed, part of the land, 27 guntas is registered in favor of the defendant number 1, and 27 guntas is registered in favor of the plaintiff's father. And it is their case that the plaintiff do not have exclusive portion of the property, and half of the building, half of the residential bungalow and the drying yard belongs to the defendant. The trial court, while considering the application filed by the parties, have looked at the revenue entries, the partition deed, and the will deed that is executed. And the court has observed that the name of T.N. Ravishankar and T.N. Ashok, that is the father and uncle of the plaintiff, were mutated in respect of 27 guntas each in survey number 156, which much earlier to mutation of name of the plaintiff. The testator of the will deed dated 10/1/2002 has not opposed or challenged the mutation in the name of T.N. Ravishankar and T.N. Ashok in respect of land to an extent of 27 guntas each in survey number 156. The court observed that the stand taken by the plaintiff through the present proposition has to be examined in a full-fledged trial. According to provision under section 94 of the Karnataka Land Revenue Act, the Karad land is part and parcel of fine land which is standing in the name of Katadar. But the plaintiff has not come up with any item of document to show that out of the Karab land as stated in the revenue document, what extent he has been in possession and where exactly he has been in possession. Even the court observes that this aspect also has to be gone into after a full-fledged trial. The court further observed that the claim of the plaintiff is completely hostile to the arrangement made through the undisputed division taken place through the partition deed dated 25/3/1970. And further, considering the fact that the mutation in favor of his father and uncle for an extent of 27 guntas was not questioned. And at this stage, as per the material on record, the plaintiff could not make out a prima facie case, balance of convenience or irreparable loss. And accordingly, court had dismissed the IA filed by the plaintiff. Aggrieved thereby, the plaintiff is before this court. When the matter came up before this court, a coordinate bench of this court by order dated
Was 11th December 2023.
11/12/2023, directed to maintain status quo in respect of the suit scheduled property till the next date of hearing, and the said interim order has been extended from time to time. Then a senior counsel appearing for the the appellant plaintiff submits that the will is undisputed. When the respondents, when the defendants are not disputing the will and disputing the will, they cannot, they are not, it is not, they are not permitted to say that the property belongs to them. It is submitted that the revenue entries that are, the plaintiff has already preferred an appeal. And although he is questioning the said mutation in favor.
The appeal stands disposed of in my favor, Your Lordship.
No, there is a further appeal even after that to the DC.
Not received, no.
No, it is, we have mentioned it in our.
They'll file they're going to file further appeal.
No, it is
with
already
regard to
filed.
the, huh?
It is already filed.
They filed a further appeal
Yes.
with regard to the revenue entries in favor of the, in favor of the defendant. It is submitted that the plaintiff had spent huge amounts, an amount of rupees 50 lakhs and lot for the renovation, and they have been residing in the said building. The partition deed also clearly says that survey number 156P of an extent of 4 acres, 24 guntas.
23.
4 acres, 23 guntas fell to the share of the grandfather. The grandfather, being the owner of the property, by virtue of the said partition, had executed a will, and he bequeathed the said properties in favor of the plaintiff. And plaintiff, after the death of the grandfather, have been enjoying the property without any interference from any corner. First time when the defendants have started interfering, he has come up before the court. It is submitted that the court has given more credence to the argument of the defendants, the contention of the defendants, than to the documents that are placed. It is submitted that the court has given more weight to the partition deed than to the will, and it is submitted that as rightly observed by the court, though the several issues have to be decided after a full-fledged trial, but at this point of time, if an injunction is not granted, it would cause irreparable loss to the plaintiff. It is submitted that plaintiff is in possession of the property, and the will deed and the partition deed also supports the case of the plaintiff, and he has made out a prima facie case, and balance of convenience also lies in favor of the plaintiff. All these aspects were not appreciated by the trial court, and the trial court had dismissed the IA. It is submitted that the court ought to have granted an injunction in favor of the plaintiff, restraining the defendant from interfering with his peaceful possession and enjoyment of the property. Next, the learned counsel appearing for the respondent defendant submits that the partition deed dated 25/3/1917 clearly shows that what is the property in survey number 156, and also what is the intention and how the properties are partitioned between the parties. He had drawn the attention of the court to para number 7 in the partition deed, wherein it is mentioned that the residential house in the coffee estate, the adjacent drying ground, and the pulper house in the coffee estate have fallen to the shares of second and third parties only in equal shares. Second and third parties are the father of the plaintiff and the first defendant. As it is not immediately convenient to divide them by metes and bounds, they shall enjoy them together and may effect division with the help of a surveyor whenever it is convenient to them. as the first party, that is, the grandfather, has not been allotted with any residential house in the coffee estate, drying ground, or the pulper, he shall have the right to use them till he makes separate arrangement of his own. All the three members shall have the common use of the well behind the estate bungalow. He has also drawn the attention of the court to A scheduled properties of the partition deed, then to the B schedule, and then the C. In in A schedule, it is mentioned that the extent of 4 acre 23 guntas in survey number 156, and the boundaries are mentioned. And it stated that it contains 3 cattle sheds and writers' quarters. When it comes to what has fallen to the share of both the brothers, it is mentioned as half the land out of survey number 156. Wet 156, wet 1 acre 15, assessment rupees 175. This land consists of residential bungalow and drying yard. This is mentioned in both B and C that fell to the share of both the sons. Basing on this, land council submits that as per the same, and he has mutated his name, and the name of his brother was mutated in the revenue records way back in the year 2011. The defendant is aware of the such entry. The plaintiff is aware of the such entry made in the name of the first defendant, which is in the year 2011. And when was the first, when he filed the appeal?
The appeal was filed in 2020.
No, I filed the appeal only, I came to know about this only when the suit I filed.
After filing the suit.
At that time in 22, 23, I filed the appeal as
After
well.
filing the suit, the mutation in favor of the defendant was questioned. He submits that the partition deed is very clear, which is of the year 1970, and also a registered document. And with regard to the registered document and the subsequent mutation in the year 2011 makes it clear that that the said partition deed is acted upon. Learned counsel submits that the grandfather cannot execute a will in favor of the plaintiff for which the properties, when he himself is not the owner of the said properties. It is submitted that the trial court had rightly considered all these aspects and refused to grant injunction as he has failed to establish before the court the ingredients for grant of an interim injunction. It is submitted that right from December, the entire night, right from December, what did you say? Proceedings are stalled or not cooperating, something is.
I merely said that after the status quo order was obtained,
It is stated that the suit is no proceed, why it is stayed, it is only status quo?
it's not stayed. It's not stayed.
Why the suit is not going on?
It
They are not appealing.
initially did not go on because they did not produce a certified copy of this order. I produced it
We are not
thereafter.
proceeding with the case.
The proceedings.
What is this?
It is submitted that the proceedings are in fact stalled. Stalled by virtue
My
of the-
submission, Your Lordship, was that for the last 12 months, the matter has been pending for plaintiff's evidence and they haven't appeared a single time before the trial.
That's what I'm asking you. It is
Apologies.
submitted that from the last 12 months, the matter is pending for the evidence of the plaintiff, and the plaintiff is not appearing before the trial court. Next paragraph. And it is submitted that there are no grounds made out seeking interference of this court with the well-considered order passed by the trial court, and the appeal is liable to be dismissed. Next, having heard the learned counsels on either side, what is the material on record? The plaintiff had filed a suit for declaration and injunction in respect of 4 acres, 23 guntas of land and bungalow in survey number 156P. it is his case that the grandfather has executed a will dated to 10/1/2022, and he died on 26/1/2003. According to him, he is in possession of the property, and the respondents or defendants are interfering, and he sought the declaration and injunction, and also filed an IA. When an IA is filed seeking interim injunction, the burden lies on the plaintiff to prove that as on the date of filing of the suit, he is in possession of the property, unless and until the injunction is granted. It would cause irreparable loss and hardship to the plaintiff. In support of his case, he is relying upon the will deed. The defendants are referring to a partition deed, and he is also party relying on the partition deed. According to the plaintiff, in the partition, the entire extent of 4 acres, 23 guntas fell to the share of the grandfather, which the grandfather has bequeathed the property in his name by way of the will dated so-and-so, dated 10/1/2002. By way of the said will, along with the plaintiff, some of the properties are also bequeathed in favor of the defendant number one. The defendant number one. As such, he has become the absolute owner of the property, and the defendants cannot interfere with the same. While considering this aspect, it is very much necessary that the court has to look at the partition deed and the partition deed and also the will deed. It is appropriate to extract the para number 1 of the partition deed dated so-and-so, page number 57. I marked the portion 1. Then with regard to Schedule B, that is point number 8 at page number 62 and page number 64, point number 9. And also para number 7. 7, that is at page number 20. Not 20, 56. From a conjoint reading of para number 7, the property in schedule number A, B, and C, prima facie shows that the residential bungalow and the drying yard is partitioned among the 2 brothers. Now, coming to the will deed, page number
91.
Coming to the will deed, it mentions above it only mentioned about coffee estate. 4 acres, 23, that is 156P is concerned. It is 4 acre, 23 guntas of land. Now, when it comes to the plaint, and it is also relevant to extract the prayer in the suit schedule property as per the plaint.
$47.
extract the schedule at 247. When it comes to the suit schedule, he has included 4 acres, 23 guntas, including Karab and bungalow, writer's quarters, is the part of the schedule. It is now, it is a case of the defendant that as far as the tea estate and the other remaining things are concerned, it is the defendants are unconnected. The defendants are only concerned with the bungalow, bungalow and the, what is that called? The bungalow. and
Only the bungalow, but only the bungalow, your lord.
Bungalow on the drying yard.
The drying yard is not described in the plain schedule property.
They're only concerned with the bungalow. The yes, they're only concerned with the bungalow. According to them, the whole basis for the plaintiff to file the suit is the will. The plain schedule is contrary to the contents and the property that is bequeathed in favor of the plaintiff. In the considered opinion of this court, the stand taken by the defendant is perfectly valid. Looking at the plaint, looking at the partition deed, the will and the plaint, it shows that the grandfather, the property that is the bungalow never fell to the share of the grandfather. Once the property do not belong to him, question of the petitioner claiming it, no, let us not go. In that view, this court is not inclined to give any finding with regard to the partition deed and the right of the parties at this point of time, as it would affect the case of the plaintiff. It is suffice to say that the material on record shows that both the parties, that is, both the brothers have to enjoy the property jointly as per the partition date. Now, the mutation in the year 2011 in favor of both the brothers in respect of that 1 acre 25?
1 acre, no, 27 guntas.
1
only.
acre 27 guntas.
No, it's merely 27 guntas to each of the brothers.
27 guntas. No, that is 1 acre, that extent is 1 acre.
1 acre 15 guntas as described in the partition deed.
1 acre 15 guntas. No, 27 guntas each is already mutated in the name of both the brothers in the year 2011 itself. And now it appears that the appeals and further appeals are filed by the plaintiff. And no other document shows that specifically that the plaintiff is in possession of the property. Plaintiff is in possession of the property. Considering all these questions of fact, which has to be decided in a full-fledged trial, at this point of time, the plaintiff cannot seek any injunction restraining the defendant from enjoying the property. However, considering the mutation in favor of the defendant in respect of 27 guntas of land is concerned, considering the mutation in respect of 27 guntas and 27 guntas in favor of the plaintiff's father.
Respondent number 2, your lord. Respondent number 2.
Then 2. As far as the defendant shall not interfere with the other 27 guntas of the land, which fell to the share of the plaintiff's father.
Grateful.
Accordingly, the appeal is disposed of. Yes, next.
Cell number 19.
Yes.
Kavita Damodaran. Cell number 19.
My lord, appearing for the appellants in the matter, my lord. My lord, I may
On some ground it was adjourned. Why?
My lord, on the last occasion, I requested a stay on the application. We are not proceeding with the stay, my lord. We'll argue that on a later date. Kindly issue notice in the matter, my lord.
Notice.
Cell number 20.
Is she directed to issue notice to the respondents? Next.
With Judith Saldana.
Yes.
My lord, I appear for the appellants. The suit was instituted by the plaintiff for a relief of specific performance, along with IA number 1, restraining the defendants from creating third-party interest. Defendants resisted the suit by filing
The suit for? Suit for
a specific performance.
specific performance. Well, what is the date of agreement of sale?
Date of?
Date of agreement of sale.
Give me a minute. Please. Agreement was dated 9/4/2023.
9/4/2023. What is the amount paid as per the agreement?
The amount which has been paid as of date is 48,82,500.
48 lakhs?
82,500 rupees.
500.
The
And
sale consideration
uh,
was 1 crore 95 lakhs 30,000.
yes. Now, on what ground the injunction was not granted?
My lord, I will just take you to the impugned order
Yes.
on page
Particular
number
para.
46 of the appeal.
Yes.
In para 18, at the last part of para 18, just before para 19, the plaintiff already availed loan on the basis of the agreement. He has to pay the interest as per his version, and if temporary injunction is not granted, defendant will change the nature of suit or alienate, which will create multiplicity of proceedings. Here, my lord, the most important words are he has availed the loan and he has to pay interest. Okay, my lord, I take you to para 19 immediately after that. Here, the plaintiff has availed loan and made agreement, and if temporary injunction is not granted, he will be put to great hardship and irreparable loss, and the plaintiff proved that he has prima facie case in his favor, and the above dictum is applicable to this case in hand. My lord, the decision of the Honorable Trial Court is rests on the fact that
You are the defendant in the suit.
I am defendant number 1 and 2, my lord. Rests on the facts that the plaintiff has availed the loan to buy the suit scheduled property, and the plaintiff is ready and willing.
Do you agree that there is an agreement between you and the plaintiff?
Yes, my lord.
Now, if you relate the property, what will remain?
I know, my lord, but I just wanted to bring to your notice the document what is given for loan, which is on page 100.
Let's forget about the loan. Even if there is no loan, let us take that he has not availed the loan. You agree that there is an agreement between
Yes, my
you,
lord.
and half of the amount is already paid to you.
Not half.
I mean, 1/3 of the amount is paid.
25%.
Is already paid to you.
Yes.
No, in the meanwhile, if pending the suit, if you sell the property, what will remain?
Yeah, but he's not ready and willing with the balance payment, my lord.
Well, where is that stand taken by you?
That is in page number 112. 112 of the appeal.
112.
112.
No, not that. How it is, he has not deposited the amount by the time of filing of the suit?
No, my lord. He has just given a loan document from the bank, which I wanted to bring to your notice, my lord. It is on page 112. I can take you through that document. My lord, he is yet to pay 1 crore 46 lakhs 47,500, the difference between the sale consideration and the amount already paid. Okay, and this document he is presented, which shows that he has
Loan application is in principle approved for rupees 1 crore 37 lakhs.
37 lakhs. Okay, that is what is mentioned. I want to bring you down to the sanction condition, line number 4, my lord. Disbursements towards construction to be linked to the stage of construction. So this is not a loan to buy the property. This is a loan for the construction. Okay, and he has to buy the property before the construction happens. So this is not a loan for the property per se. This is a loan for the construction. Further on, I will take you, my lord.
Or else will issue emergent notice or take a hand summons to the council appearing for the respondent before the trial court. Now, at this stage, we shouldn't interfere with any of this order. Once he comes and basing on what, we'll decide the application itself.
But this is a loan which is purely for construction, my lord.
That is true. That's why I'm saying, no, once he comes and he says that, then once he is not ready and willing to perform his part of the contract, and if he has not deposited any amount before the court by the date of filing of the suit, then we'll pass orders. But at this stage, not to alienate, that's the order which can't be interfered.
And this money will be paid to the contractor, to the architect, and to the engineer, not to the.
We'll consider all that. The registry is directed to issue emergent notice to the respondents, post after service of notice. Or if you want to take notice on the hand summons, the petition.
No, my lord, let it go. I'm in notice.
Yes. Next.
Cell number 21. K. Kumar K.
Yes.
My lords, plaintiff's appeal.
Oh.
Challenge, my lords, interim order passed and the interim application was challenged here, my lords. The plaintiff sought
Interim
for
application is not
not allowed, rejected. So basically, my lords, suit for permanent injunction. My lords, the impugned order at page number 14, my lords.
Yes.
My interim application was rejected on the only ground that, my lords, I have purchased the property from the GPA holder. Last 4 lines of the page 14, my lord. May I read, madam? The plaintiff purchased the suit schedule property from said Muniraju under registered sale deed dated 22/2/2012. After the purchase, plaintiff is in possession and enjoyment of the suit schedule property. Plaintiff is claiming his right over the suit schedule property based on GPA holder of his vendor and affidavit without seeking relief of declaration.
Notice is not issued to the.
Notice is issued, my lord. Original owner subsequently
While this order is passed, notice is not issued.
Notice issued. Emergent notice is issued.
Thereafter, what I am asking you is, while this order is passed, the defendant was not heard.
Not heard.
So we will set aside this order and ask the trial court to hear it.
Please.
The present appeal is filed, agreed with an order passed, order dated 12/8/2024.
My lord, one submission. Any observation made in connection to annexure K at page 50? The original owners, once again.
Let the court, let there be a detailed order.
Please.
What is this? What is
Please.
the appreciation?
I put on.
Agreed with the order. Agreed with the order passed in I number 1. 1 dated 15/7/2024. The plaintiff is before this court. The plaintiff had filed a suit for injunction. It is his case that, where is the plaintiff?
My lord, plaint at page number.
The plaintiff that plaintiff is absolute owner and peaceful possession and enjoyment of the suit scheduled property. That property belongs to one Srimati H. Kariyamma and Sri H. Virappa, and they both executed a general power of attorney along with an affidavit dated 5/1/1985 in favor of. What is this general power of attorney along with? That is not a registered general power of attorney.
That is not registered general.
Then how that property will be?
That is why, my lords, I beg your attention to look at annexure K at page 50. The original owner came and executed a confirmation deed in favor of the plaintiff.
The dated 5/1/1985. On the strength of the said document, the plaintiff was in continuous possession and enjoyment of the property. And then a registered sale deed was executed on 22/2/2012 for valuable sale consideration. And the same was registered before the sub-registrar, Penya, Bangalore. And ever since he has, and petitioner continued to be in possession of the property. Even the kata extracts and tax paid receipts are standing in the name of the plaintiff. He has also produced an encumbrance certificate for 14 years. It is a case of the plaintiff that on 7/7/2024, the defendants and their henchmen had attempted to enter the suit scheduled property, shouting slogans that they are the owners of the property and they know how to take back from the plaintiff, which made him to come up with the suit. And also an IA, the trial court by order impugned had dismissed the, had not granted any order. And observed that the plaintiff is claiming his right over the suit scheduled property basing on the GPA holder of his vendor and affidavit without seeking relief of declaration. Hence, it is not a fit case to grant ex parte in view of the same. Emergent notice is issued and suit summons to the defendants, and the matter is directed to be listed on 12/8/2024. The trial court on this court, considering the arguments of the counsel for the appellant and also looking at the order, the trial court had, whether the notice is served on the defendant or not, on 12/8 shall consider the application of the appellant for permanent injunction and a permanent injunction. Accordingly, the appeal is disposed of. This court has not issued notice to the defendant as in the said order by the time the defendant had not appeared before the court. Yes.
Still the disposal of the IML.
Yes.
22, TP Muttanna. For petition. Appellate.
Yes. Yes.
This is the debt recovery matter, my lord. Here, my that respondent and appellant is a secured creditor, my lord. They granted loan to respondent number 2 and 6. They are the borrowers. And then they are defaulted in payment of the amount and all. Then under invoking the provision of Surface Act and all this, property was sold. And against sale of the property, they approached the Honorable High Court by filing a 2-writ petition. The 2-writ petitions were also dismissed. Immediately, the moment and the property was, the sale certificate was issued, sale certificate registered in favor of auction purchase, and possession was also handed over to him. Now, immediately after dismissal of the 2-writ petitions, my lord, one person named by Shivakumar, he is the respondent number 1. He filed one original suit before the trial court, stating that he entered into a joint development agreement in the year 2008. And because of joint development agreement, he is in possession of this entire property. And that is why that he has got the possession of the property, and he has sought for restraining bank and other respondents from interfering with the peaceful possession of the property. In fact, this property was mortgaged to the bank in 2015. And that
to him, when is the agreement?
2008. And this is not a registered joint development agreement.
Then what did the court do? Please come.
And court accept that joint development agreement. There is no other documents at all produced to show that, and he claims he is adverse possession. How, my lord, that adverse?
Come to the order.
My lord, that.
Where is the finding?
That is page number, it starts from page number 18, my lord. And your lordship may kindly see, my lord. Very lengthy judgment, and my lord, and
Please
without
come to the findings straight away.
findings. My lord.
Then maintainability of the suit was not argued.
No, that, my lord, that application was filed, but the auction purchaser before the trial court stating that suit is not maintainable as per the 34 Section 30 Surface Act. That he has rejected. No, I can maintain because he is claiming that was possession. I can proceed with the case. And very surprisingly, my lord, these things, and in normally, my lord, there is already apex court judgments are there, that suit is not maintainable. And when the Surface Act or DRA, the action under DRB Act is taken.
So please tell the court, when was the sale conducted?
My lord, sale was conducted,
When was the possession taken?
sale certificate,
Say, sir,
That Annexure D, my lord, page number 76 to 83.
please give the date. Say,
One
sir.
124. 1/1/24 CL certificate was issued in favor of the auction purchaser, respondent number 8. Then against the issue of the CL certificate, my lord, he approached the Honorable High Court by filing the 2 writ petitions. That is Annexure E, page number 84 for 90.
What are the number of the writ petition?
Writ petitions 85544 of 23 and 1883 of 24. Sorry, sorry.
What are
255, my lord. 255 44 of 8.
Let us go to that. Where is that page number?
Page number 84 to 90, my lord.
84. WP number 1883 and 25544 of 2020.
Yes, my lord.
Dated 14th March. What did the learned judge say?
That both the writ petitions are dismissed, stating that the bank has sold the property in the, as per the provision of Surplus Act, and it is not maintainable and all this. That is the.
This is filed by the plaintiff in the suit.
This is filed by my lord, that owner of the property, that is a borrower.
No, the suit is filed by this person who is claiming adverse possession.
Adverse possession.
When is the suit filed?
Suit was filed, my lord. On 6/11/2024. You know, no, it is not correct, my lord.
11 has not yet come.
It was filed on.
No, it is 14/3/2024.
43/2025.
Order to take 27.
That is on the same day.
14/3, on the same day. That is what my writ petition was dismissed.
On the same day suit is filed.
Immediately, so he filed the suit. I think whether there is collusion between this borrower and this person, that also we are unable to find out. How this person came to know that suit is, writ petitions are dismissed.
Please come. The agreed with the orders passed in I number 1 and 2 in OS number 1923 of 2024. Which is the bank?
IDBI Bank, my lord.
IDBI Bank.
The IDBI Bank, the secured creditor is before this court. It is submitted that which defendant is the borrower?
Borrower is the respondent number 2 and 6.
Is defendant number?
Defendant number. One second.
Please come to the cost title
That
of
defendant number 1 and 2.
1 and 2.
Yes, my lord.
The defendant number 1 and 2 have defendant number 1 and 2 have availed the loan from the, which respondent you are, or from the sixth respondent, sixth dependent bank. Defendant number 1 and 2 have taken loan from the sixth dependent bank by mortgaging the property. As thereafter, as it has become an NPA, and they obviously initiated the proceedings under the Surface Act, and the property was put to sale. Sale certificate was issued on 1/1/2024, and auction purchaser was given possession of the property. Then a writ petition is filed by the owner on before this court, that is 25544 of 2023 and 8883 of 2023.
188.
18883 of
1883.
Huh?
1883.
1883 of
Yeah.
2023. Both the writ petitions came to be dismissed on 14th March 2024, that the writ petition is not maintainable. Then on the same day, the present suit is filed by the plaintiff stating that he has entered into an agreement of sale with respect to the said property way back in the
Entered into agreement, joint development agreement.
joint development agreement when?
Entered into joint development agreement. Annexure G, my lord.
What is the date?
1 second.
He has entered into a joint development agreement with the defendant number 1 and 2. With the defendant number 1 and 2.
That is on First April 2008.
8th April.
2008.
8th April 2008.
8 April 2008. It is a case of the defendants 1 and 2 had mortgaged the property in favor of the bank in the year 2015. 15. It is contested before the court that in respect of this property, the suit is not maintainable and the plaintiff could not make out a case as physical possession was taken and it was delivered to the auction, to the sale certificate was issued and the auction purchaser was put in possession of the property. The trial court, in spite of the same, had granted injunction, considering the submission of the land conflict petition, considering the fact that this, in respect of the very same property, the sale certificate is issued on 1/1/24, and the auction purchaser is put in possession of the property. There shall be an order of status quo.
My lord, auction purchaser has also filed another MFA, my lord, it is pending for this.
We'll post along with it. There shall be an order of status quo, post along with so and so. Registry is directed to issue notice to the respondent. Oh, I think, but he has to be served, plaintiff has to be served.
Yes, ma'am.
Post along with so and so, give the number. Yes, next.
Cell number 23, Kashina JD. For petitioner, Sandesh P. Nadiger.
Yes.
Kindly have given short adjournment.
Was this matter at the request of the non-counsel petitioner on 22nd of August? Next.
Cell number 24,
First petition is by the wife and second petition is by the husband. This is the proceedings initiated, my lord, under 125 CRPC.
Where is the respondent?
First petition also not appearing, my lord.
Is it so? You are appearing in RPFC 202.
202, yes, my lord.
Counsel for the petitioner in RPFC 202 is present. By the counsel for the petitioner in RPFC, counsel for the petitioner in RPFC 137 of 2022 is not present before this court. Post RPFC 137 of 2022 for dismissal along with this petition on August 27th.
Yes.
Yes.
cell number 25, Satish TV.
Petitioner. Producing the cash paid receipt.
What is this? $4,000 to the advocate for petitioners. Then counsel had filed a memo to show that the cost imposed, the cost as directed with this court are paid to the respondent post this RPFC on 9th of September. Yes, 26.
26,
Petition.
cell number 26.
Petition, my lord. I challenge the order, my lord, passed by second edition of family court, my lord, in criminal miscellaneous
Is
86.
served
Yes, my lord.
on to the
already served.
respondent. We'll see it on Tuesday. Post this matter on Tuesday.
My lord, the present due is also paid.
We'll take it on that day, Tuesday.
Cell number 27, adjourned. 28,
Tell them,
Present the petition in this case.
yes.
cell number 28, Akash Shah Rao.
Represent the petitioner, ma'am.
Yes.
So an order passed under 125 has been challenged before.
No Reddy B.
Interim order is there.
Interim order is.
There's no representation for the respondent. Post this matter on September 10th.
Grateful.
Number 29, Anant Kumar C for petitioner, Vishwanatha Regde for respondent,
No representation to both the parties. Close this matter on 11th of September. 11th. Yes,
still
I
number
appeal for the respondent, Lord. 29.
29, counsel for the respondent is, any interim order in this?
Lord, there is an interim order directing payment of 10,000 rupees as maintenance. But
No
that is being
representation for
paid.
the petitioner. Counsel for the respondent is present. Pose this matter for dismissal on Wednesday.
Please.
Yes.
still number 30, adjourned, 31, Arun Govindraj.
Here for the petitioner, appearing for the respondent, Your Lord. I kindly recall, this is the case where the father had not seen the children for a year and a half.
Hmm.
The Lord was pleased to make an arrangement half an hour every day, and then thereafter for 2 hours over the weekend. Lord, for once, my Lord, I have no submissions to make except if my Lord permits me. There's a video of about 70 seconds, if your Lordship would kindly, where Lord, the children, how they interacted with the father on the minute they saw the father. Lord, I have no arguments to address.
Take it, we'll
Yes.
take it
Yeah.
from you that it went on well.
Extremely well, but the children, Lord, they cry when the father has to leave. Despite seeing him after a year and a half, Lord, December 2022 was the last interaction.
What was the order last time?
My lord, I have a small submission, my lord. My lord, the matter may be taken up this Friday because the senior counsel who's appearing the matter is held up before the double bench in this particular court hall, Your Honor, in arguments. So it is posted for today for the quantum of maintenance as such, so it may be taken up.
I'm
Yes,
looking
yes.
at the order. Then counsel the petition further submits and the father undertakes to pay the maintenance
Yes.
regarding the quantum of maintenance. He'll submit before the court on 7/8.
Yes. Lord,
What are your submissions on
yes,
that?
the instructions are this, my Lord. The respondent has withdrawn 3 crore 15 lakhs in the span of 1 year, all supported by bank statements, my Lord. I have all the documents with me. Notwithstanding, the father is paying 12 lakhs, my Lord, per annum towards school fees alone for both the children, apart from 1,35,000 rupees per month towards the respondent's
12
rent.
crores per annum to the school fees.
12 lakhs.
12 lakhs.
12 lakhs for both, 7.5 lakhs for the son, 4.5 lakhs for the daughter. School fees being paid, 1,35,000 rupees per month is the rent that's being paid towards the respondent, the children's residence.
No, that is done. Then what about the
My lord,
maintenance?
my lord, Lord, I will make the statement, my lord. If I
My lord,
try
the
to-
matter may be taken up this Friday as such.
No order adverse to your will not be passed. So please wait, please see. Nothing, no order will be passed. Yes.
Lord, may I make this,
Yes.
if it appeals to the court, my lord, about 15 to 20,000 rupees per month, I will pay over and above what I'm already paying.
15 and 15.
15 or 20,000 rupees per month, not over. I'm paying 1,35,000 rupees towards rent every month. 1 lakh towards educational expenses every month. Lord, over and above, my salary is 3.9 take home salary. I'm taking a rented place myself,
What is the rent of your place?
65,000. I'm staying in a 3-bedroom apartment, 65,000 rupees. I will place all the documents on record.
Well,
But I have not.
My lord, we will place our reply to the same answer.
No orders will be passed.
May I make one request, Lord? No, I understand.
I'm only trying to understand so that some interim arrangement
Yes.
before passing a final order. Some amount he'll pay. That's what I'm just asking him. So
Sure.
no order will be passed.
15 to 20,000 rupees a month, my lord, pending decision on further decision. Lord, I'm paying close to about 2,35,000 rupees a month is what I'm already paying. And she had, my lord, bank statement 3 crore 15 lakh rupees. 44,000 rupees comes as interest to a joint FD that's already frozen by the bank. Apart from that, my lord, I have bank statements that the affidavit of assets and liabilities filed by the wife before the domestic violence court. 24 lakhs she has received, my lord, in a span of 12 months. Her own bank statement.
Lord, we'll be able to show, my lord, that it is my own money which I had loaned, which he has returned. We will be able to show.
So it's not a person without means. 3 crore 15 lakh rupees.
Question is not person about means, my lord. There is, as he says, my lord, there may be money in my account in fixed deposit in the name of kept for the children, my lord. But he has to give something at least on monthly to monthly basis, my lord. But he wanted to meet the children.
He says he is paying 2.5 lakhs per month.
To whom?
1.5 lakh for the rent.
135, yes.
175 for the rent.
135.
No, no, what he was saying, that's
Okay.
what. Now we have to see what is his, what is his, no, the salary or what is his income?
Yes.
And now he's paying and 12 lakhs per annum to the children.
Before there was any dispute between the.
No, no, 12 lakhs
Hmm.
towards the school fees.
No, it's
So
not
that is
12 lakhs.
1
No,
lakh.
it's,
per
it's,
annum.
it's not exactly 12 lakhs, my lord.
Not 12 lakhs.
They may produce the
That
documents.
shows- I have receipts. I have receipts here.
That clearly shows he's a man of means, my lord. He's saying, I have only 3 lakh rupees per monthly salary.
No, let
Can
him
he,
pay,
can he,
because
my lord, sustain with this?
Fees, nobody can generate.
No,
What they have
he may not be
paid, they can-
generating that. What I'm saying
If
is,
it is, no, what I'm saying is 1 lakh on that and 1.75 or 1.35 for the rent. So as of now, he's paying 2.35. The court is not suggesting that because he's paying that he need not pay the maintenance.
Correct.
So he's paying 2.35. So for pay, his income should be somewhere around 5 or 5 lakhs at
according
least.
to us, it's about 8 to 10
Ah,
lakhs.
Then only you can ask something else to be. So what is the material placed before the trial court?
We'll show that.
With regard to that.
We'll show that.
So basing on that, we will.
We'll show that. And he himself has made an admission there that he's depositing in the children's name 1.5 lakh rupees per month for their college education. Today, what will happen? They don't have anything to eat. Why doesn't he give that?
Now, may I make this request, my lord.
He's meeting the children every day.
That arrangement came to an end yesterday. So this
No, no,
week,
we'll continue.
I don't want, my lord, I understand.
We'll continue, sir.
No, my request is this. I stay in Hebbal. She stays in near
No,
White.
no, with the expression the senior counsel, Mr. Arun Govindra has thought that it won't happen. Yes.
No, my request is this. I stay in Hebbal and, my lord, she stays in Whitefield. No, weekends, if I can go pick up the children on Saturday evening and drop them back on Sunday evening, my lord, for the next 2 weekends, and thereafter the matter could be taken up. So I will also ask him, my lord, how much more he can come up with towards children's maintenance. 2.3 from not is not
Suddenly,
disputed.
no, that bargain can't be.
No, it's not a bargain.
Some parity.
Absolutely not. Absolutely not.
What
No,
is
the
working,
children
let
are
it
not missing
work.
me. No, if your lordship sees it, it's a 1 minute video. If your lordship sees that video, your lordship will understand, my lord, the bond that the children have with the father. What is being portrayed before court is that I am some monster who beats up my own children. My children don't want to see my face. They're seeing me after 1.5
So
years.
by this order, you're meeting, the father can meet the children between 7.
Half an hour every day.
The clubhouse or the apartment,
Yes.
then he can meet the children from 4 PM to 6 PM. In
Weekend.
the clubhouse on, that is on the weekend.
Weekend.
No, let it
No,
continue for another week.
Continue for 1 more week.
Then
I'm all the way not from, at least I could get.
No, but you're having, see, 2 weeks,
Yes.
2 hours. No, day to day, if you don't want, okay, then that
Can we
week.
increase my Saturday,
No,
Sunday, at least I have holidays.
No, no,
instead of
what
traveling
you
every
do,
day. my lord.
instead of
four
Four hours
every
on
day,
Saturday, Sunday.
4 hours on Saturday.
every day, then the weekend will increase it.
4 hours on Saturday, Sunday. Mother is it?
4 hours on Saturday, Sunday means each.
2 hours or 4
Four
hours?
3 to 7 Saturday, 3 to 7 Sunday. That's what.
Hmm.
But this Saturday she has a birthday.
3 to 7.
Okay, right.
But
The-
the lordship's order specifies that the mother should not be around.
She was not there.
Yes, she was not there. She was not.
Then why?
No,
That's what
let
it
that
is.
continues on.
No, when it is happening, this is what.
Sorry,
this is
I
all
apologize. My apologies.
31/7/2024, this court passed an order whereby permitting the father to exercise the visitation rights and also ask the father to come out with the maintenance that he'll pay to the wife and the children. Today, when the matter came up, and then counsel for the petitioner submits that the visitation went on very well and he had good time with the children. When it comes to the maintenance, it is stated that per month he is spending an amount of rupees
2,35,000.
35,000 towards the rent and also towards the educational expenses of the children. His salary is
3.9 lakhs per month is take home salary.
0.9 lakhs per month. And it is submitted that she, over a period of 1 year, she has withdrawn an amount of rupees
3 crores 15 lakhs.
3 crores 15 lakhs. 15 lakhs. And it is submitted that he'll be able to pay another 20,000. Next, senior counsel appearing for the respondent by submits that, in fact, his salary is
But between 8 to 10 lakhs.
between 8 to 9 lakhs. And the very same arrangement, when all of them were together and paying the school fees and the rent, when he was able to maintain, now why he is not able to maintain, nothing has been stated, and he stated that they will place on record all the documents to show that what is the income of the father. Considering all this court is passing the following order. 1, the father can meet the children on Saturday and Sunday between 3 to 7 in the clubhouse. Saturday and Sunday, that is 10th and 11th of August. Number 2, at the time of exercising the visitation, the mother should not be present and both the parties, the father and the mother shall not create any kind of disturbance and shall see that the visitation goes on smoothly. Any kind of disturbance from either of the parties will be viewed seriously by the court. By post this matter on 21st of August.
There's a matter in Delhi.
The other weekend also, my lord, 17th and 18th. There's one more Saturday, Sunday.
21st of August.
Lord, 21st, there is a problem, Lord. Can it be?
22nd?
22nd.
Post on 22nd of August. Then one more Saturday, Sunday is coming on 17th and 18th.
18th.
That also you add. And by that time, by 14th of August, the wife shall file all the documents pertaining to the pertaining to the husband's income and all, and a copy shall be served on the council. And by the date of hearing, if any objections, the same shall be filed.
Obliged.
Yes, next.
Cell number 32,
Daily visitation.
Suresh Babu being Ganesh G for respondent.
Lords, in pursuance to the orders of your lordships, my lord, we dropped the kid at the mediation center, Kolar, my lord, and the father interacted with the kid.
The visitation went well, my lord. The kid was happy. There was no sort of an issue, my lord.
That is why what my respectful
No,
submission.
it is coming up before this court for the first time.
No, my lord,
No.
last
What
occasion
it-
when it
That's
had
why let
come
me
up,
just
it
look
was
at
been-
it. I don't remember this
Lord,
case.
what my respectful submission is, my lord,
Court had granted the state of the name to. Oh, this is the case where police station.
police
one.
station,
Ah.
please.
This is order about the mother and the child have to go to the police station.
What the interim arrangement that was made by your lordships, let that be continued, my lord, for some time. If the child get acquitted, we'll see, my lord.
On Saturday between, in the mediation center in the family court.
Please.
Please, my lord.
Let it continue.
Yeah, let it continue, my lord.
We'll have it after a month.
Yes, my lord, please.
We'll post it after a month.
But I would request your lordships, it can be disposed of also with that interim arrangement.
I think
So
it
that
can be.
will first and third Saturday.
Yes.
So that I can drop it there and,
The present, where is the interim order? Where is the order passed by the child court?
Lord, it is at page 15, Lord, the operative portion is at page 15. Sorry,
The
page
present-
26, please. ma'am.
Present petition is filed.
Page 26.
The order is passed in I number 7 in GNWC number 9 of 2022. Dated 26 June 2024. Whereby
Page 26, ma'am.
whereby the court has passed, the trial court has passed the following order at page number 15, please extract 15 and the next page also. Agreed with the said arrangement made by the family court. The mother is before this court. This court having heard both the counsel for the appearing for the mother as well as the father on 1/8/2024, wherein this court had directed the father to exercise the visitation rights on 3rd August 2024, that is on Saturday between 1 PM to 5 PM in the mediation center of the family court. Today, both the parties are present before the court, and it is submitted that the visitation went on well, and this the order of the court may be modified, and this arrangement may be continued. Considering the submission of both the parties, the order of the family court dated so and so in so and so is modified, and the parties are permitted to, the father is permitted to exercise the visitation right.
Visitation rights along with custody
On-
rights, my lord.
Huh?
During that period, visitation rights and custody rights, my lord.
Custody will be
Custody rights,
difficult,
my
let
lord.
it get admitted, my lord.
Visitation is different.
Because the honorable trial court has been passed in a visitation rights.
The problem,
with
Lord,
the- She has given to the child to the
First
custody of the
of all,
father.
this let it go on for some,
My lord,
for
yesterday,
2 months.
Saturday,
Let
she
it
will.
go on for 2 months, then you can seek for, no, when the
But
girl
so-
is not comfortable.
No, my
why
lord,
are you
the-
doing
she-
it?
comfortably yesterday, the Saturday, she was.
Because she was sitting somewhere in the mediation.
4
the-
hours, so will sitting
between
idly, my lord.
One,
That is the reason. my lord.
disposed of in the following manner. The father shall exercise the visitation rights on Saturday between 1 p.m. to 5 p.m. in the mediation center of the family court number 2. This arrangement shall go on for 2 months, and later, once the girl is comfortable, for the interim for interim custody for during that time, to take her to take her out or to meet her at outside without the mother, the father can move an appropriate application.
And monthly 2 times or 1 month?
Huh?
Monthly 2 times?
No, every week.
Please, my lord.
No, my lord, third and second and
Some
fourth,
holiday issues.
second and fourth Saturday, there will be holiday, my lord. First and third Saturday, let him visit.
Alternatively, that
First and
Once
third
the
Saturday.
child, once the child get acquainted with,
First and
then,
third Saturday.
please, my lord.
Yes.
and during that period of time, my lord, she will interruptedly interference of the visitation.
Mother shall cooperate with the same and shall not
Cooperate
be-
with, she will
Saturday
cooperate.
Saturday also she was,
Yes,
unnecessarily
yes, yes,
Because we can't
next.
leave alone.
Yes, 33.
Bill number 33.
Please, my lord.
Respondent. S.V. Prakash.
Petitioner.
Lordship, kindly see the order sheet.
Every time they are not coming. Tomorrow at 2:30. Yes. Yes, next.
Bill number 34.
Matter, I for the respondent, please. Matter has been settled between the parties. Kindly have it on Monday, please. 12.
One, it is submitted with the counsel, the respondent that the matter has been settled. Hold this matter on Monday. Yes, 35.
Bill number 35.
35 for the appellate one. There is a
Notice
delay.
is ordered in this?
Notice is served, my lords.
Huh.
My lord.
Give it. When is it served?
My lords, through court it is served, my lords.
What is the delay?
My lords, delay is,
IA number 1/24 is filed to condone the delay of 42 days in filing the appeal. For the reasons stated in the accompanying affidavit, the delay of 42 days is condoned. Yes,
my lords, on merits, it's a miscellaneous, my lords.
yes.
The ex parte decree has been passed.
Oh.
My lord, so the notice was not served on the the appellant's hearing, my lords.
Mm.
As per, my lords, subsequently, my lords, the suit has been decreed. A miscellaneous petition has been filed.
We'll dispose it off on
Yes, my
Friday.
lords.
Post this matter on Friday. Yes, next.
Bill number 36. Dhananjay Kumar.
Respondent.
K. Chandran.
Petitioners, my lord. My lord, for the IA number 1, the delay of 16 days may be condoned. Because my lord, first time, due to the oversight, we have filed MA in the Sessions Court, and then we subsequently we have filed a writ petition. And now, when the writ petition was disposed of with the liberty to file,
You should have filed something else then.
now we have filed
Then,
MFA.
then
my
some
lord.
more days delay would have come. Will condone the delay.
Yes, yes.
IA number 2 of 24 is filed to condone the delay of 160 days. It is submitted that they are pursuing the matter before they filed an MA and later a writ petition. As the same is not maintainable, now they have come up with the present appeal. And in that process, a delay of 116 days occurred. Considering the same, the delay of so-and-so is condoned. Post this matter for.
My lord, I would like
Correct.
to make a submission on
Yes.
IA number 2.
No, not today. IA number 2. Yes,
But I
next.
need to file objections also.
For what?
IA2, for stay, because they sought injunction in the trial court, that came to be rejected. I am the.
We will look at the trial court order. If we feel that it is there, we'll, otherwise we'll, yes,
Please.
pose this matter on 13th. Yes,
Much-
next.
Much obliged.
37.
Yes.
37.
Your Lordship, you kindly say that the appellant, the daughter and mother
Yes,
filed a suit for partition,
yes.
wherein your Lordship is against a husband and brothers,
37?
37, my lord.
Yes,
Daughter and mother filed a suit for partition against a husband and 2 brothers.
Hmm.
That suit came to be dismissed on the ground that during the lifetime of a father, she is not entitled for a share.
Hmm.
Then appeal is preferred. During the pendency of the appeal, then your Lordship can see that father was passed away. That earlier courts have declared that the father is having 3 items of the properties are self-acquired properties. Then your Lordship, the Honorable High Court decreed the suit and granted 1/4 share each in the property of a father. in view of the Vineet Sharma case. Then thereafter, your lordship can see they have filed a review petition, the respondents, contending that they have during the lifetime of their grandfather have executed a will, unregistered will. For that, they have filed a P&C case and obtained a letter of administration, probate. Because of that reason, review petition is filed. At that time, he has produced a copy of the order. Then immediately we obtained the certified copy and filed this appeal, my lord. Because your lordship can see even father not executed the will. Fraudulently, they have obtained the will and obtained the probate.
Who are the respondents?
Respondents are the grandchildren of Munusamappa, who is my father. The sons.
Will issue notice?
Please, my lord.
Notice. Notice to the respondents.
38.
Short date may be given, my lord. Even the lawyer is appearing in the review petition, my lord. We will serve the copy on him because of this order, my lord, no review petition is going to be allowed.
Who is the counsel? We'll print its name. We'll see then.
Mr. Shiva Reddy.
Print the name of Mr. Shiva Reddy for the respondent.
K.N. Shiva Reddy.
Pose this matter on Friday. We'll see if he appears then. Yes,
Please,
or else.
Number 38.
Appearing for the petitioner. 202 days delay, your lordship. There is a delay in this one.
For the respondent. For the respondent. Last occasion, this lordship has directed me to file a calculation regarding how much they paid and what is the balance. Take the instruction from the.
Memo of calculation.
2 weeks time.
Your lordship, when will you file?
2 weeks time will be granted.
When it was on 24/7, you asked for time. Again, you are asking time now. It is their revision. Pose this matter finally after a week.
Delay may be condoned, your lordship, because it's.
IA number 1 of 23 is filed to condone the delay of 202 days in filing the appeal. Then counts for the respondent submits that he has no objection to condone the delay for the reasons stated in the accompanying affidavit. Delay of 202 days is condoned. Next.
Your lordship, kindly, interim order may be extended.
Interim order earlier granted is extended post after 2 weeks.
Appearing for the petitioner, your lordship, the petition is against the dismissal of the 125 application. Emergent notice may be issued, my lordship.
Yes. Emergent notice received directed to issue. Emergent notice to the respondent.
Any date may be.
After service of notice.
Petitioner, my lord. The present petition is for enhancement of the interim maintenance that was granted in the trial court, my lord. A date may be fixed, my lord. Yesterday, we have received the objections from the respondent and also we are filing a reply to the said objections. Any convenient date?
This matter, the request of the counsel, the petition on 28th August.
Your Honor, I have a submission to make. I am the respondent party in person, Your Honor. I have also moved a stay petition on 28th of June, which is on the execution what they have filed for the same impugned order which they have come before this court to get it quashed, Your Honor. There is one impugned order which is in question, which is for quashing before this court, and in the family court they have filed a execution petition on that very same
No,
But there is a
you have
deliberate-
not, you have not filed any petition before this court. Then the execution will go on.
Yes,
No, if
but-
they are seeking enhancement, it doesn't mean that they cannot seek for the execution. They can do it.
But Your Honor, I have also filed a review petition for the review before the same court for the very same impugned order, after which they have filed on a second thought. They have filed a execution petition where I have already given them 2 checks of 25,000 each.
Unless
Your
and
Honor.
until there is a stay on execution, they are at liberty stay, the execution will go on.
Yes, Your Honor, for that, I have filed a stay petition before this honorable court.
How can you
Your Honor,
file
in
a
this,
stay petition in
Not-
their
There
case?
is a misdirection, my lord. Nothing has been filed before this court. The application.
it
for
is in
stay
this matter I have filed the,
has been filed before the trial court in the execution. Since one application has been filed, my lord, it is yet to be decided.
Yes,
It is a
next matter.
misdirection.
Case number 41.
Madam.
Shruti C. Chatterjee.
I need a week's time to have the claim petition, my lord. This is in Kannada, my lord. I need to secure the document. Kindly grant me a week's time.
Was this matter on 10th of September, at the request of non-counsel for the petition.
42. Nityanand,
My lord, praise 2 days for,
Huh?
praise 2 days to feel, to
No,
file.
maintainability of the appeal,
My lord, only 2 days.
Friday. At the request of learned counsel for the appellant. Yes,
cell number 43, adjourned 44. Cell number 44,
Petitioner.
A. Srinivas, compliance with office.
File the objection is copy is received, my lord.
interim order in your favor,
Please, my
no representation for the respondent. Pose this, no represent, counsel for the petitioner is present, no representation for the respondent. Pose this matter on 9th of September.
interim order may be continued.
Interim order earlier granted is extended till then.
45,
Ma'am, we were asked to file an affidavit with proof that my
Where
wife
is your advocate?
is in the another court hall, Your Honor.
No, this is not lower court.
I
parties
know
will
that,
not
I know that.
appear. Your client, your advocate has to come before the court, not you.
Yes, Your Honor.
Huh?
Your Honor, the
Why, last time also you're not present? Huh?
day before yesterday, 4 days ago, I saw their lawyer in Bangalore Club, Your Honor.
Pose this matter on Monday.
Thank you.
Request of learned counsel for the respondent.
Thank you, Your Honor.
Yes. Tuesday.
Thank you, Your Honor.
Yes.
Thank you.
cell number 46, adjourned 47.
47 to 49 for all these matters. Let 47 be there in the list. And 48 and 49, let it come on 18th of September.
Lordship, shared it by
Number-
serial number 48, Your Lordship.
Huh.
We'll have it the next week, Your Lordship, because you will be retiring in the next year, Your Lordship. Without granting.
I'm appealing for respondent.
Without service of notice, the expert order has been obtained, Your Lordship.
So it is false submission.
We will see, we'll have it on Wednesday. If it reaches, we will take. Post it on
Lordship.
Wednesday.
Much of.
Lordship, Lordship, inconvenience on Wednesday.
Then we'll post it tomorrow. Tomorrow you argue.
Please, Lordship, but Lordship, this is the evidence is in Kannada.
Why? For everything, evidence has to be read.
But Lordship,
For MFA.
no, because there is some Lordship, evidence has to be read because Lordship, there is admission on their part.
So you do not want this matter to go on.
No, I'm ready, my Lordship. I'm ready. I'm
Yes,
ready.
We will see Wednesday. Yes, next.
Wednesday, my Lordship, on that day, my Lordship.
Yes.
50. Serial number 50.
Lordship,
Anya Rai.
on 13th, my Lordship, in
13th, yes.
Yes. 13th only. That's what is posted Wednesday. Yes.
please.
Yes.
Serial number
50.
50.
I'm in 50, Your Lordship. He mentioned, I think, in 50.
He's mentioning about not 50, the earlier matter, I think.
I'm in 50. I do not have urgency. It's any date is okay.
Serial number 50.
Vacating the interim order, you will not have, where are the
But they're not-
respondents?
But serial,
Manjula, serial
230.
number 50.
230 list, my lord.
Ah.
There is urgency, my lord, because my lord, he filed a MC petition for divorce, and my lord, there, my lord, an interim order for maintenance, my lord, to her. He got the stay order from this honorable court, but he is proceeding with the case there. Now, my lord, the arrears is 4,20,000 rupees.
Post is
Let him-
50 and 51 top of the list tomorrow. Yes, next.
Serial number
52, my lord.
What is happening? in
52,
that?
my lord.
What has happened in that?
Passover matters.
Last time you said that, is it about the hospital?
Psychiatrist.
My client is agreeable.
No, they said that there is no hospital or you will find out or
Bangalore,
something.
there is no.
Then what is to be done?
May I make a submission,
Here
Your
no.
Lordship? We have ascertained the psychiatrist details, Your Lordship. The matter may be referred to him, Your Lordship.
Who?
The child psychiatrist, pediatric psychiatrist had to be appointed in this. We have ascertained the details of the psychiatrist.
Where are they?
It's in Mangalore, Your Lordship.
Give it to
Okay.
him.
I don't know. Madam.
Give it to him. You can have check out. You can check it up. Oppose is 3 tomorrow. We will pass orders top of the list.
52,
Please,
madam.
referring the matter. Please find out from your client.
Yes.
Tomorrow.
Lordship, 48 on tomorrow itself, Lordship, 48.
Wednesday.
Serial number
Lordship,
70.
Wednesday is inconvenience.
It's not Wednesday, Thursday. Yes.
Tomorrow.
Tomorrow.
in serial number 17,
Pass
Huh.
over.
will be taken after 10 days, please, my lord. I have to produce certain documents. One second.
No, the other day also, you were not there.
No, I was there, my learned friend was.
Let it be there. They are
No,
saying
I
that there is some urgency. We will see. We'll
I
see.
have to produce certain documents which
Who
are
asked you to produce? The court asked?
to produce. to
If the court
establish
feels, then you can produce it. but
Certainly,
you
my
can't.
lord, they are in Telugu. I need to just answer.
They are in,
Telugu language.
then I can
I
understand.
understand, my lord. I should have.
No,
I
I'll
should
make you
understand in the
understand
first
what
place.
is it in Telugu.
I-
Let us see when they're asking, when they're insisting, even he was there.
No, I was held up in the other court, otherwise I
No,
was.
no. You have a stay in your favor.
I understand.
Give
I'm
them
not.
Give them an opportunity to get the stay vacated or to continue.
It's a church which being constructed for a public and they have taken a status quo and they have got grant.
According to them, it is.
That will get.
Tomorrow,
Yes,
that matter tomorrow.
Yes.
Yes.
Serial number 7, pass over.
Not
serial number
tomorrow,
7.
Monday at least.
8.
Monday.
Monday.
Please don't ask for
No, I
time
am
on
not
Monday.
seeking yet.
Even if you're not there also, we'll decide.
I understand.
Yes. Oh,
Serial number
Interim
7.
order has to be extended.
yes.
Serial number 7, I pay for the appellant.
Huh.
Any date tomorrow or day after tomorrow?
It says MFA of 2017.
Yes, ma'am. I am ready now, it's open.
Why is it passed over?
Because his morning.
Where I was held up in the other court.
Let it.
It's, I had filed a suit for money recovery.
Let it come tomorrow.
Oh, yes, sir.
Yes, next.
Serial number 52, my lord, tomorrow.
15. Top of the list. will come. It's done.
Court officer, madam.
50-51. ಆಯ್ತಾ?
Madam.
ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಇದನ್ನು ನಾಳೆ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಬರ್ಬಿಡಿ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡಿಸ್ಕೊತಾರೆ ತಂದು
Court officer, madam.
ಇರಪ್ಪ ಸೆಕೆಂಡ್ ಇದೆ ಹಾ ಹೇಳಿ ಸರ್
Madam, 48.
ಥರ್ಸ್ಡೇ
ಯಾವ-
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ 15 ರಜಾ ಇದೆ
Okay, madam.
15
Next Thursday, 15th ಅಲ್ಲ madam, 15.
ಥರ್ಸ್ಡೇ ಅಲ್ಲ ವೆಡ್ನೆಸ್ಡೇ 14
ಅದೇ 14 ಅದಕ್ಕೆ 13 ಕೊಡಿ ಅಂತ 14th ಇರೋದಿಲ್ಲ ಮೇಡಮ್ ನಾನು.
ಎಲ್ಲ ರಜಾ ಇದೆ 28th ಹಾಕ್ಬಿಡು ಅದು
ಓಕೆ ಮೇಡಮ್.
ಇದು ಇದು ಅಜಯ್ ಪ್ರಭು ಎಲ್ಲಪ್ಪ
48 ಮೇಡಮ್.
ನಂಬರ್ ಹೇಳ್ರಿ
48.
ಸೀರಿಯಲ್ ನಂಬರ್
48.
48 ಥರ್ಸ್ಡೇ ಅಂದ್ರು ಮೇಡಮ್ ಮೂರು ನಾಳೆ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಆಗಿ ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ನೋಡೋಣ ಸೀರಿಯಲ್ ನಂಬರ್ 48 28 ಹಾಕು ಬಿಕಾಸ್ ಥರ್ಸ್ಡೇ ಅಂದ್ರು ಮೇಡಮ್ ಥರ್ಸ್ಡೇ ಇಸ್ ಹಾಲಿಡೇ ಫ್ರೈಡೇ ಇಸ್ ಹಾಲಿಡೇ ಸ್ಯಾಟರ್ಡೇ ಸಂಡೇ ಹಾಲಿಡೇ 48 ಅಂದ್ರು ಅದು 28 ನೆಕ್ಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಅಷ್ಟೇ ಹೌದು ಹೌದು ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ಸ್ ಯು ಶುಡ್ ಬಿ ಪ್ರೆಸೆಂಟ್ ದೇರ್ ಅಲ್ಲಿ ಕಾಲ್ ಔಟ್ ಆಗಿರುತ್ತೆ ಹೋಗಿ ಬೇಗ 47 88 ನಾಳೆಗೆ 43 48 ಐವೋ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ನಾಳೆ ಇರೋದು ಮಾಡ್ಬಿಟ್ಟು ನಿಮಿಷ ಇದೆ ಅಯ್ಯೋ ಲಾಸ್ಟ್ ಇಂದ ಒಂದು ತಗೋಣ 50 ಅದೆಲ್ಲ ಆಯ್ತಲ್ವಾ 51 ಟಾಪ್ ಕರ್ಬಿಡು 88 52 ಇನ್ ಚೇಂಬರ್ಸ್ ಹೋಗ್ತೀನಿ ನಾನು ಇದು 49 ಒಂದು 18/9 ಅಪ್ಪ 18 ಸೆಪ್ಟೆಂಬರ್ ಅಂತಾರೆ ಮಹಾಬಲೇಶ್ವರ ಓಕೆ 49 18/9 ರಿಪೀಟ್ ಒಂದು ಕಾಲ್ ಲಿಸ್ಟ್ ಕೊಡಿ ಎಲ್ಲ ಬರ್ಕೊಟ್ಬಿಟ್ಟು ಹೊಟ್ಟೋಗ್ತೀನಿ ಆಮೇಲೆ ಕೊಟ್ಬಿಡಿ ನಾನು ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟ್ರಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಇದೆಲ್ಲ ಸೈನ್ ಮಾಡಿಸ್ಕೊಂಡು ರಿಪೀಟ್ ಕೊಡ್ತೀಯಮ್ಮ ಹಾ
ನೀವು 3 ಅಲ್ವಾ?
ಹಾ ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಇದು. ಸೀರಿಯಲ್ ನಂಬರ್ 15 ಒಂದಿದೆಯಲ್ಲ. 52 ಇನ್ನು ಇನ್ ಚೇಂಬರ್. 52 ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟ್ರು. ಅದೊಂದು ಅಪ್ಡೇಟ್ ಮಾಡ್ಬಿಡಿ, ನಾನು ಮಾಡ್ತೀನಿ ಅಲ್ಲಿ. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಆಸ್ ಇಟ್ ಈಸ್ ರಿಪೀಟ್. 47 ನಾಳೆಗೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 47 ನಾಳೆಗೆ, ಆಯ್ತಾ? ಆಮೇಲೆ 13 ಅಲ್ಲ, ಅದು 28 ಅಲ್ಲ, ಥರ್ಸ್ಡೇ ಅಂದ್ರು. ಥರ್ಸ್ಡೇ ರಜಾ ಇದೆ. 28 49 ಬಂದು 18/9. ಅಲ್ಲ, ಅದು ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಇದ್ರೆ ನೋಡಿ, ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ 49 89 ನೋ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್. 89 ಅಲ್ಲಿ ನಮ್ಮ ಬೇಡ, 49 ಸೆಪ್ಟೆಂಬರ್ 18 ಅಂತ ಹೇಳಿ. ನನಗೆ ಇದು 89 ಅಂದ್ರು. ಆಮೇಲೆ ಅವರು ಕೇಳ್ಕೊಂಡಿದ್ಕೆ ಅಯ್ಯೋ ಇಲ್ಲ ಡೇಟ್ ಇದ್ರೆ ತಗೊಳಲ್ಲ. ಒಂದ್ಸ ಅದು ಆಲ್ರೆಡಿ ಇದಿದೆ, ಡೈರೆಕ್ಷನ್ ಇದೆ. ನೀವು ಇಲ್ಲಿರ್ಲಿಲ್ವಾ ಮತ್ತೆ? ಸರಿ ಕೇಳಿಸ್ಕೋಬೇಕು ಸರ್, ಸರಿ ಕೇಳಿಸ್ಕೋಬೇಕು.